Everyone. Am I audible?
Good morning. Yes, you are audible. Just one thing
Yes, you are
I
audible,
wanted
sir.
to mention. This is Shalini, an IP. I think in yesterday's email from ICICI, they mentioned the time as 2 p.m. to 5 p.m. That needs to be, I think, corrected by them.
Hmm.
Ma'am,
I
today
think
morning I have sent the revised mail with the correct time.
Okay.
Good
Thank
morning.
you.
You are very much audible. Thank you.
can we start?
Yes, sir.
Okay. Good morning, everyone. Welcome to today's workshop on the role of Committee of Creditors, need for accountability and transparency under the IBC code. As we all know, the Committee of Creditors plays a central role in the corporate insolvency resolution process under IBC. It represents the collective decision making body of financial creditors, exercising significant powers in approving resolution plans, replacing resolution professionals, and deciding on liquidation. While the COC's commercial wisdom has been recognized by courts as paramount, recent jurisprudence emphasized the need for greater accountability, transparency, and fairness in its functioning. The COC decisions must align with IBC's objective. IBC objective means value maximization, time bound resolution, and equitable treatment of all the stakeholders. We will also discuss the landmark judgment on this topic. Judgments such as Vijay Kumar Jain versus Standard Chartered Bank and Phoenix ARC Private Limited versus PAD Financial Services Limited 2021 have clarified that the transparency, access to information, and bona fide participation are essential to maintain the integrity of the resolution process. Today's workshop aims to highlight the role and power of the COC under the IBC, the need, just 1 minute. Okay. The need for accountability and transparency in its decision making, judicial developments shaping the COC functioning, best practices for insolvency professional to ensure fairness and compliance. By end of this session, participants will have a clear understanding of how a transparent, responsible, and well-informed COC can strengthen the effectiveness of the insolvency resolution framework. We will cover First, we will discuss preamble, objectives, role and power of the Committee of Creditors, Committee of Creditors, need for accountability and transparency under the IBC 2016, Committee of Creditors, what are the key challenges as we have to face uh, by the COC and criticism under the IBC code, and then we will discuss so many landmark case on this topic. First, we will discuss the preamble because we need to first discuss what are the objectives because as per objective, COC and insolvency professional have to work as per the IBC code and also what are the role and powers because unless until we will discuss on this, after discussing we can align what should and what must be need for accountability and transparency under the IBC code for COC. And when we know what are the accountability and what transparency we should have in the CRP process. So then we also need to discuss what are the key challenges we have to face the COC. And when we are stuck up, when we are means don't have any clarity related to any section or any there is any concern, there is any issue, then we have to refer the landmark cases related to that issue. That judgments really guide us how to come out of that issues. What is the preamble? The Insolvency and Bankruptcy Code represent one of the most significant and transformative reforms in India economic and legal landscape, enacted to consolidate and amend the laws relating to the insolvency and bankruptcy companies, limited liability partnership and individuals. The code aim to promote entrepreneurship, ensure timely resolution because our main objective is uh, maximization of the value. Also, within a time frame as prescribed in the IBC code, ensure timely resolution of the insolvency, maximize the value of assets and balance the interests of all the stakeholders. This is the prime objective of this code. The IBC marked a paradigm shift from a debtor in position regime to a creditor in control, because earlier our focus was on the debtors in position. Now, after implementing, after this act, after this code, the regime has shifted to the criterion control framework, emphasizing time-bound resolution instead of prolonged liquidation. Earlier, there was a note, means a time frame. As IBC code, we have to means do the complete the resolution process within 180 days plus 30 days extension plus 30 days extension. Maximum in 330 days we have to means complete the resolution process. Now, as of now, there is a time means given कि we have to complete this process within this time frame. Earlier, there was not means fixed target or fixed time, and it was taking very much time to resolve the means insolvency cases. At the heart of this new ecosystem lies the committee of creditors constituted under the section 21 of the code, which act as the decision making authority during the CRP, because all the commercial wisdom decisions are only taken by the COC. So that's why it's means there is a accountability and transparency need, because when only commercial decisions are only taken by the COC, so then there must be a transparency. So to ensure to ensure the balance the interests of all the stakeholders. The COC, comprising financial creditors, holds the power to approve or reject resolution plans, replace the resolution professionals, and decide on liquidation. Among other vital functions, the decisions of the COC are guided by the concept of commercial wisdom, a principle recognized and upheld by the Supreme Court of India, landmark judgments K. Sridhar versus Indian Overseas Bank and Committee of Creditors of SR Limited versus Tish Kumar Gupta. There are so many landmark cases on this topic. Later on, we will discuss multiple landmark cases, and that landmark cases will clear us कि what are the exact accountability and transparency need in the resolution process, and why this need. What is the purpose? What is the objective? The judiciary has constantly reiterated that the commercial wisdom of the COC is known justiciable, meaning that the merits of its business decisions are not subject to judicial review, provided they are made within the framework of law. The recognition of the COC autonomy was intended to ensure that the financial decisions are taken by the most competent to assess business viability, because as all the commercial wisdom decisions are taken by the COC, and COC only financial creditors are the member of the COC. As per this code, we also know the financial decisions can be better taken by the financial creditors, because there are financial creditors, there are operational creditors, but with commercial decisions are can be taken better taken by the financial creditors. That's why in COC only financial creditors are the member. Has simultaneously given rise to critical debate on the need for accountability, fairness, and transparency in its functioning. While the IBC grants extensive powers to the COC, it also implicitly expects a corresponding degree of responsibility. In practice, issues such as lack of transparency in the evaluation of resolution plans, unequal treatment of characters, perceived biases, insufficient disclosure of reasoning, and inadequate record keeping have surfaced during several high profile insolvency proceedings. Concerns have been raised that in some instances COC decisions may not fully align with the broader objective of value maximization. When any means stakeholder raise any query, any questions, so in that case, if COC is transparent, so then it's very easy to prove that all the decisions are taken in the interest of the all the stakeholders, not only in the interest of the financial guiders. Because it's presumed if COC may or can take only in decision in the favor of the financial character, but that is wrong, because COC have to take all the decisions in the interest of all the stakeholders, not only in the interest of the financial guiders. So that's why any stakeholder, any authority can ask any raise any query, any questions. So if COC is transparent and fulfilling their accountability as per the objective of this code, so it's very easy to prove that all the decisions are taken in the interest of the all the stakeholders. So that's why in the in CRP process or liquidation process, there is a necessity for transparency, and transparency can come with the accountability. Moreover, the complex interplay between resolution professionals and the COC has attracted attention. The RP acts as a facilitator, ensuring that the process is conducted in accordance with the code and regulations. However, the RP operates under the directions of the COC, leading to situations where questions of independence, influence, and procedural fairness arise. The balance between professional independence of the RP and commercial discretion of the COC remains a crucial area for discussion and reform. As we know, we resolution professional means work only as a facilitator. We cannot take a commercial decision as resolution plan is approved by the COC. We are only facilitator as per this code. We cannot take the commercial any decision. The need for accountability and transparency in the functioning of the COC is therefore not merely a procedural or regulatory concern, but one that strikes at the core of the credibility and the effectiveness of the insolvency resolution framework. Enhanced accountability ensures that COC decisions are made with due diligence, fairness, and integrity, while transparency fosters confidence among all the stakeholders, including operational guider, employees, and investors. Because there are so many stakeholders in the resolution process: operational guider, employees, investors, and also a government authorities, and also regulators. Because when any company goes into the liquidation process, first resolution professional will work as a facilitator, and COC will take the commercial decision. There will be a stakeholders, because all the claims will be submitted with resolution professional. All the claims will be passed as per the objective, as per this code. So there are government dues also submitted with the resolution professional under this code. So means government authority and other authority and regulators, and because we have to submit and report to the means authorities, and we have to follow the instruction of the NCLT. To mean there is adjudicating authorities also. So these are all the stakeholders, and we as a resolution professional have to work as a facilitator. But resolution plan, if for example, if registered valuer submit their valuation report, okay, resolution professional will go through the valuation report, okay, and resolution valuation report will be means submit with the COC members. COC members will go through that valuation report. On the basis of the valuation report, they can take the decision related to resolution plan. But it's not mandatory. They will take the decision on the basis of the valuation report. COC will only refer that valuation report. Okay. Recent judicial pronouncements and regulatory developments have emphasized this need. The IBB discussion papers, NCLT Ancillate observations, and Supreme Court's guidance in cases such as a JP Infratech Limited, Amtech Auto, and Diwan Housing Finance Corporation Limited have highlighted gaps in COC conduct and underscored the importance of structured reasoning, disclosure, and ethical conduct. The IBB has also explored frameworks to enhance COC accountability, including proposal for a code of conduct for COC members, mechanism for periodic disclosures and measures to ensure that decision making aligns with the principle of fairness, efficiency, and value maximization. In the background, the workshop on the role of the Committee of Creditors, need for accounts, accountability, and transparency under IBC Code seeks to bring together insolvency professionals, bankers, advocates, academicians, and regulators to deliberate upon the evolving role of the COC in the insolvency resolution process. What are the objective? The objective is to develop a nuanced understanding of the statutory and fiduciary responsibility of the COC. Okay, what are the responsibilities? The legal boundaries of the commercial wisdom. Because COC members, COC committee have to take all the commercial wisdom, commercial decisions, but in the legal boundaries. Okay, they are to, because if they are to means approve anything, so this everything or every activity will be aligned as per the legal boundaries, as per the IBC code, because IBC code is also says ki value maximization timely. Okay, means if commercial wisdom are not taken on the time, so then what will happen? It will impact on the resolution process. If there is a mandatory to complete the resolution process within time frame period, COC member will have to take the decision within timely, with the purpose of the value maximization and also in the interest of the all the stakeholders. So these are the legal boundaries have to follow by the COC members as per the IBC code 2016. So means what are the statutory and fiduciary responsibilities of COC?
Sir, are you moving your presentation? This is static. It's not move. It's not turning on the pages.
No,
It's stuck on the page one.
just a 1 minute. I will again attach. Now it's moving.
Yes, sir. It is.
Yes, it's moving.
Okay.
Yes, now it is available.
Okay,
Yes.
okay. Sorry. See, I will show you from the first slide.
Yes,
Actually,
yes. Please show it from first slide because
yes,
nothing
yes,
was visible
yes.
from beginning.
In first
Yes, please,
slide,
please.
we discuss ki in index we will cover preamble, objectives, role and powers of the Committee of Creditors, need for accountability and transparency under the IBC code, Committee of Creditors, what are the key challenges and criticism under the IBC code, and also we will discuss the landmark cases on this topic. And in preamble, we have discussed this first page. So now we were discussing this thing. The objective is to develop a nuanced understanding of the statutory and fiduciary responsibility of the COC. What are the legal boundaries of commercial wisdom? Ethical and professional obligation of COC members. What are the ethical and professional obligations have to follow by the COC members? The role of the resolution professional in ensuring transparency. Okay, RP is also responsible to ensure that there is a transparency in the CRP process. Okay, because RP is also working as a facilitator. So he is also responsible for, he is also accountable for transparency in the CRP process. And next is the judicial expectations and emerging trends from case laws. The reforms needed to strengthen the framework for accountability and transparency under the IBC code. Through this presentation, interactive discussion and case studies, the workshop aims to generate meaningful insights and recommendations for reinforcing in the integrity of the insolvency resolution process. It will also seek to promote a shared understanding of the balance between commercial autonomy and regulatory oversight, ensuring the IBC continues to achieve the intended goals of the value maximization. Because our main objective is to, as per this code, is value maximization, to work in the interest of all the stakeholder along with timely resolution. So these are the main objective of this code. Okay, and according to this objective, there are uh, accountability and responsibilities for COC, and as per this code, the power and authority is given to the COC members. When power and authority given to the COC members, they are also accountable for transparency because all the stakeholders want equal treatment. If they are COC members are fair and taking decision in all the interest of the all the stakeholders, so then just 1 minute. Then it means there is a proper accountability and transparency is in the system. So means COC must ensure accountability and transparency in the functions, because otherwise any stakeholder who is not means or think that there is a not equal treatment, then they can directly approach to the educating authority. Then educating authority will come into the picture, and then it will take more time to resolve the issue. So that means the objective will defeat, because objective of this code is to complete the insolvency resolution process within a time frame period. So means it's core responsibility of the COC members to ensure accountability and transparency functioning of the committee of the guiders. Why? This is vital not only for the success of individual insolvency proceedings, but also for the credibility and sustainability of India's insolvency regime as a whole. The effectiveness of the IBC depends on the trust and confidence that all the stakeholders, we have already discussed, there are multiple stakeholders: creditors, debtors, employees, investors, government authorities. Okay, and also we have to report to the adjudicating authority as per this code. So there are so many, because we have to submit the reports with the adjudicating authority, and all the final approval of decisions approved by the adjudicating authority. First resolution plan will be approved by the COC, but also we need the approval from the adjudicating authority to complete the resolution process. Place in the fairness and integrity of the process, this workshop thus represents a step forward in promoting those values and strengthening the foundation of India's insolvency resolution framework. Now that was the preamble. Now we will discuss the objective, because as per this objective, COC members have to work, because unless and until we will take care of the objective of this code, so then we will not be able to complete the process as per this code. What are the objective as per this code? The IBC says IBC was enacted as a comprehensive legislation to consolidate and amend the laws relating to the insolvency resolution for companies, partnership firms, and individuals in a time-bound manner for the maximization of value of assets and balancing interests of the stakeholders. So that is the core objective we have already discussed. But this code is for companies, partnership, and individual in a time-bound manner. That is very, very important, because the main objective of this code is to complete the resolution process within a time-bound manner. As we have discussed earlier, before this code, there were so many legislations was there, but they were not emphasizing to complete the resolution process within a time period. So it was taking very much time. When it was taking very much time, the value of the assets was not maximum, because, for example, earlier, if any company is was going in the resolution process in 1990, okay, the value of the assets was 100 crore. If it is taking 10 years time, so then value of that assets will reduce drastically. So means before this act, we were unable to achieve that objective. If resolution process will be in the time frame period, so then value of the assets will be on maximization side. So that is the main objective of this resolution process as per IBC code. Our core objective first is time bound manner, but for the maximization of the value of the assets and balancing interest of the all the stakeholders. That is the core objective of this code, and very important, and that is the heart of the IBC code. It represents a paradigm shift from the erstwhile debtor-friendly regime to a creditors-driven model, emphasizing revival over liquidation. Time-bound resolution process, essence of time-bound resolution, one of the most fundamental objective of this IBC is to ensure that the process of the insolvency resolution process take place with the strict statutory timelines. Prior to IBC insolvency proceeding in India were plugged by prolonged delays under multiple overlapping laws such as SICA, RDDBFI, SURFACI. Cases would drag on for years, eroding assets value and reducing recovery for creditors. Okay. To counter this, the IBC introduced a definitive timeline-driven process ensuring quick decision making and faster economic recycling of capital. What are the statutory timelines of this code? As we know, 180 days. Okay, with extension 30 days plus 30 days, we have to complete all the resolution process within 330 days maximum. But normal time is 180 days. Statutory timeline is 180 days to complete the CRP process. But due to any reason, if adjudicating authority means if with you provide adjudicating authority, the extension is given 30 days plus 30 days. Means a one-time extension of 90 days may be granted by NCLT under section 12(3) if the instructed by the COC. What are the statutory timelines? Section 12(1) of the code mandates completion of the CRP resolution process within 180 days from the date of admission of the application by NCLT. A one-time extension 90 days may be granted by NCLT under section 12(3) if instructed by the COC. Now, what is the responsibility here in COC? If COC will take more time or much time to take the decision, financial commercial decision, so then it will impact on the timeline. So that is the accountability for the COC members to take all the commercial wisdom decision within a time frame period. Okay, otherwise means resolution process will not be completed within a given time frame period as per the IBC code. So that is the COC responsibility. Okay, and COC will have to transparent ki why when they received means that report. Okay, what are the actions taken by the COC members? Why time taken so much, and what decisions are taken by the COC members for the interest of all the stakeholders? There is need to for a transparency. Section 12(3), second proviso, as per the 2019 amendment, the entire process, including any extension, any litigation period, must be completed within 330 days. Okay. The strict timelines ensures certainly minimize value erosion, because if that resolution process will complete within a 330 days, so the assets value we can recover maximize. Okay. Otherwise, if it will take say 5 years, then what will happen? If any company is in resolution process, which is manufacturing company, they have their own plant. Okay, plant will not means will not in working condition. Maybe if the plant will not operate, so the machinery will maybe not in position in working condition, or maybe due to the technology changes, the value of these machines will drastically reduce. So that is the main core objective, to resolve resolution process within time frame period, so that maximization of value of the assets may be recovered for the interest of all the stakeholders. This strict timelines ensures certainly minimize value erosion and promotes discipline in the financial ecosystem. So that was the first objective, statutory timelines given also in the as per the IBC code. We have to follow these statutory timelines, and we have to complete the CRP process within time frame period. That is the means mandatory. Rationale behind the time bound resolution, preservation of going concern value. The faster a distressed business is resolved, the higher its resale value. Prevention of asset typing. Delays often lead to deterioration of assets, loss of key personnel, and decline in customer confidence. Certainly, for kites and investors, quick resolution enhance predictability and improve credit culture, macroeconomic stability, efficient resolution process, improve overall ease of doing business and capital availability in this economy. Okay. Judicial recognition of timelines. Courts have constantly upheld the importance of adhering to the statutory timelines. S.R. Mittal, India Private Limited versus Tish Kumar Gupta, the Supreme Court emphasized that the court aims for speedy resolution and not money recovery. Okay. Committee of Creditors of SR Limited, Tish Kumar Gupta, the court reaffirmed that resolution within fixed timelines is essential to maintain the court's effectiveness and to prevent indefinite delay. Another case was Abix Singapore Private Limited versus COC of Aducom Solution Private Limited 2021. The Supreme Court observed that the undue delay in resolution defeats the court's primary purpose and impact assets value. Because if resolution process will not be completed in time frame period, so then definitely it defeats the core objective of this court. The core objective of this court we have already discussed. Second one is maximization of value of assets. Core objective. The maximization of the value of the assets is another cornerstone of the IBC. The code doesn't aim merely at debt recovery for creditors. Rather, it focuses on the reviving and restructuring. Okay, the resolution process. Our focus is to revive the business during when we are in the resolution process. Our objective is to revive the business. Okay. If revival is not possible, then business will go into the liquidation. If we will go in the liquidation process, so then our aim to sell the assets to recover the maximum value of the assets and distribute the proceeding as per the waterfall mechanism. But during CRP process, our aim is to revive the business, and our means objective and approach will be as a going concern approach when we are talking about the CRP process. It focuses on the reviving and restructuring the corporate debtors as a going concern to preserve value, because in CRP process or CRP phase, we are not means our aim to close the business. When our aim is to revive the business, that means we are working on the going concern approach. Okay, when business will go into the liquidation, then our approach will be different. Then our approach will be to close the business, to sell the assets, and distribute the sale proceeds as per to all the stakeholders as per the waterfall mechanism. So these are the two approaches. There are two different approaches. That's why when company goes in the resolution process, insolvency professional have to hire two registered valuers. So then when the registered valuers means do their valuation, so they also do the valuation, and in this resolution process for the means insolvency CRP process, they also use the going concern on the basis of the going concern approach, because in this phase value of the maximization of assets is more as compared to the liquidation process. So then our approaches will be different in both the means situation of phases. The legislative intent is clear from the preamble to the IBC, which states to consolidate and amend the laws relating to reorganization and insolvency resolution in a time-bound manner for maximization of value of assets of such persons. Why maximization of value of matters? For creditors, higher recovery through revival instead of liquidation. Okay. For employees, continuity or employment and protection of livelihoods. Okay. For economy, preservation of productive assets and promotion of the entrepreneurship. Okay. For investors, strengthening confidence in the legal and financial system. C. Mechanism facilitating value maximization. Resolution plan approved by COC members. Okay. When resolution plan is submitted by the resolution applicant, then COC members go through and approve the resolution plan, which is more or more value maximization. The COC evaluates and approves resolution plans that provide for maximum access value and viability. Valuation by registered valuers. Two independent registered valuers determine fair and liquidation value. Because as you know, as per this code, resolution professional have to hire two registered valuer for different class of assets, two registered valuers for each class, and registered valuer have to submit their valuation report with the valuation professional, and then after going through, if everything is okay as per this code, in legal terms, so then the report is submitted with the ROC, with the COC. COC also go through that report, and that report give us the idea what is the value of the company, what is the value of these assets. So on that basis they can take the decision to approve the resolution plan. But I am again telling you, COC members uh, can refer, but they are not means bind or statutory, or it's mandatory to take only on the basis of the decision on the basis of the registered valuation report. So they are independent, that they can take decision in the interest of the business. They COC members only refer that valuation report. Competitive bidding process. The resolution process encourages multiple bidders to enhance realization value. Information memorandum ensure complete disclosure of assets and liability, facilitating informed bidding. Liquidation as a last resort. The code prioritizes resolution over liquidation to prevent destruction of the value. When resolution process fails, okay, so then company will have to go to the liquidation process, but that is the ultimate situation. The first or the main objective of this code is to run the business, to survive the business with the help of the resolution professional or COC committee. But if COC committee doesn't approve the resolution plan, if they don't get the resolution plan, if survival is not possible, then company will go into the liquidation. That is the ultimate situation for the company. What are the judicial endorsement of value maximization? Swiss Ribbons Private Limited versus Union of India. The Supreme Court observed that the value maximization of value of the assets is the most important objective of the code, which benefits all stakeholders, not only creditors. Because when there will be a maximization of the value of assets, so then it will beneficial for all the stakeholders. Why? Financial creditors will be able to get their may given loan, number one. Number two, employee will be able to get their salary and other things, and other stakeholders. For example, operational creditor. Operational creditor will also be able to get their payment, and government authorities means if they government authority have also to recover as a dues, as a tax, so they can they can or they will be able to also get their money or their dues. So means maximization of value of the assets will be beneficial for all the stakeholders. And also when revival of the business is there, so then if employees are working, so then they will be able to work for long term. Their job will not means they will have not to leave the job. So maximization of value of the asset is important for all the stakeholders, not only creditors, because creditor will get their money back, but also they will be able to be business in future also with that company. So maximization of the value of the assets is important for all the stakeholders. Another case was SR Steel cases. The court noted that the COC member ensured that its decisions lead to maximization of the value of the assets of the corporate debtor, not merely recovery of few lenders. Okay, because as we know कि in COC only financial creditors are the member of the COC. Okay, means when they are taking commercial wisdom decisions, they are taking decisions for that company. They are not taking only decision for the for the interest of the only financial creditors or few lenders. Maharashtra's seamless emptied versus Venkatesh 2020, the court clarified that the value maximization is not synonymous with highest bid. The focus must be sustainable resolution, ensuring long-term viability. Because this is not a one-time exercise. Ki if one resolution plan submitted by the resolution applicant with the highest bid, so then COC have to approve that resolution plan. COC committee have to see ki which resolution plan is the beneficial for the company for a long term, not a one time. This is not a one time exercise, because if company is to survive, if business is to survive, so COC member will have to take the decision for the company for a long term perspective, for not a short term perspective. Value maximization can be get when COC members are taking decision in the interest of the business for from long term perspective. For main objective will be value maximization. If as of now, if I'm getting 100 crore rupees more, but if in case if survival is there, so if company can generate revenue more than 100 crore in coming period, so then decision must be or should be taken by the COC committee in the interest of the business for from long term perspective. Role of COC in value maximization: the COC is entrusted with the responsibility to access the commercial viability and ensure that chosen plan maximize value in the aggregate. This involves careful evaluation of resolution application plans, because COC committee have to evaluate the resolution plan from long-term viability for the purpose of value maximization, use of fair scoring or evaluation metrics. Because if COC members getting multiple resolution plan, so they have to means properly analysis of all the resolution plan, which resolution plan will be more beneficial or more give benefit or in the interest of the all the stakeholders, in the interest of the business. Okay, so they can give score, because score means they can evaluate which plan is better, balancing interest of different characters classes, ensuring decisions align with the objective of the court rather than short-term gains. Means COC committee should take decision for long-term perspective, not for short-term gains. If one-time gain is there, so that is not means serve the purpose of this code, because value maximization will be for long-term perspective decision. Balancing of interest and economic revival. Although time-bound resolution plan and value maximization are two distinct objectives, they are deeply interconnected. Okay. Delay reduce value. Efficient and transparent decisions by the COC preserve and enhance it. The code seeks to achieve this delicate balance while ensuring equitable treatment of all the stakeholders. As we have already discussed, if it will take much time, so then the value of the assets will drastically reduce. and the code of objective is to maximize the value. And when decisions are taken in time frame period or in timely, so then we can means take the decision in view of value maximization, and both are interconnected. Time bound resolution, if time bound resolution is there, so then we can get the maximization value of the assets. If time bound is not there, so then there may be means reduction of the value of the assets. And when time bound resolution process and value maximization is there, so then equitable means then we can also means take the decision or equitable treatment for all the stakeholders as per this code. Because when company goes into liquidation, so then as per waterfall mechanism we have to distribute the sale of the proceeds. So then it means ki we are giving the equal treatment of the stakeholders as per this code. Means there is a standard process and procedure already defined in this code ki how to do, what to do, and what not to do. All things already mentioned and cleared in this code. If in although if we face any challenges, so then we can refer the landmark cases. Landmark cases also are very important in practical life, because all the landmark cases give us guidance how to resolve this problem and this issue. If there is confusion or there is means not clarity as per this code on any or particular any section or any miss topic. Now we will discuss the role and powers of the committee of creditors. That is also very important to understand what are the role and powers as per the this code given to the committee of creditors. Because when we will discuss the role and powers, according to the role and powers, there must be accountability and responsibility for the COC. Role and powers of the committee of creditors. The committee of creditors is the central decision making body in the CRP. Under the IBC code 2016, the code has vested the COC with significant powers to ensure a creditor driven and time bound resolution process. The COC represents the collective will of the financial creditors and exercise commercial wisdom to decide the fate of the corporate debtors, whether it should be revived through a resolution plan or liquidated. The relevant powers of the COC primarily given to the section 21 to 30 of the IBC code. So what are the powers are given to the COC? Constitution of the committee of creditors. That is the first step. The COC is constituted by the interim IRP after collection and verification of claims received from creditors. Only financial creditor, as defined under section 5(7) of the code, form part of the COC. In case where a corporate debtor has no financial debt or all financial creditors are related parties, then code provides the operational creditor above prescribed threshold shall form the COC. Once constituted, a resolution professional convenes and conducts meeting of the COC and acts under its direction and control. Okay, means first insolvency resolution process will constitute within a time period COC committee. Once COC committee constituted, so then resolution professional, because in first meeting COC members committee take the decision, either they will change the IRP or they will approve IRP to work as a resolution professional. Once they approve or appoint a resolution professional in their first meeting, after this first meeting, resolution professional works as a facilitator. Then all the decisions are taken by the COC members, and resolution professional have to take approval from the COC related to major things, for example, resolution plan. Okay, so all the commercial wisdom decisions are taken by only the COC members. These commercial decisions cannot be taken by the resolution professional. So what is the role of the committee of the characters? The COC plays a multifaceted role: supervisory, decision making, and commercial in guiding the entire. Because if any resolution plan is submitted by the resolution applicant with the COC committee approves the resolution plan, then adjudicating authority will review that resolution plan, means in terms of the legality, not in the terms of the they will not go into the resolution plan. They will see as per legality, as per this code. If resolution plan is okay, so the adjudicating authority will approve the resolution plan. Its functions are not merely procedural but fundamentally to achieving the objectives of this code. What are the role of the committee of characters? Number first is custodian of characters interest. Okay. The COC represents the collective financial interest of all characters and is tasked with maximizing recoveries through effective resolution strategies. Its decisions determine whether the corporate debtor continues as going concern or proceed to liquidation. Because COC takes commercial decision, all the commercial decisions must be in the interest of all the stakeholders. They cannot take the decision only for few lenders, only for financial guarantors. Their decision must be equitable and in the interest of all the stakeholders. Their decision must be in the interest of the business. Okay. So that means COC, committee of characters, is the custodian of the characters interest, because characters interest means financial character as well as operational character. They will not take only decision in the interest of the financial character. They will take the decision in the interest of the all the characters, and in the government authorities or government dues are also covered under the operational characters. So that's why all the decisions will be taken by the committee of characters in the interest of the financial character as well as in the operational character. So they cannot take decision only for a particular group. Okay. Now, when
Rajinder ji,
yes.
just one question. I'm interrupting you. This committee of creators generally comprise of financial creators.
Mhm.
Although, okay, in the code and all, it says that they should look after the interests of all the creators. But by and large, COC members are interested in only their recovery part, how much they are able to recover. This is if you see, major COC members go with this attitude. And this is a fact. It is not that it is not a fact. It is a fact that they are interested in their recoveries. And very few, I have rarely seen that, they are interested in the operational, because by and large, the dues of financial creditors are far in excess of the plan value which you get. So they are first interested in only their recovery and not at all bothered about the operational creditors. This is a fact, and it is true also. So I don't know how much, although you are saying that they should take care of the operational creditors, but very few in practical life, very few of them take care of operational creditors. They are just interested in their recovery. And by and large, as I said, the main reason being the plan value is such that generally it is less than the dues of financial creditors alone. That is the thing.
See, you are saying right, but as per act, they have to take the decision in the interest of all the stakeholders. If any stakeholder is not agree, so then then aggrieved party can approach to the adjudicating authority. Because as per law, as per this means code, they will have to take decision in the interest of the all the stakeholders. As per code doesn't say कि you can take decision only in the interest of the financial guarantor. So in practically means if any party is aggrieved, so then they can approach to the adjudicator. And in when we will discuss later on the landmark cases, in these landmark cases, it's clearly defined. The aggrieved party directly approach to the adjudicating authority. So that is adjudicating authority is there. Practically, you are saying right, because when all the financial creditors are only the part of the COC, so maybe sometimes or in some of the cases, if they are taking decision only in the interest of the financial creditors and they are only focusing to recover only their amount. So, for example, then what will happen if aggrieved party will go to the means adjudicating authority? If adjudicating authority also means find key decisions are not taken as per this code or in legal terms, so then company will have to go to the liquidation process. So then as per means waterfall mechanism, the sale proceedings will be distributed. So we will cover these things na, means in the when we will discuss the landmark cases na, so we will discuss in detail.
Okay, okay. Please continue.
Okay. Strategic decision maker, the COC evaluates the viability and feasibility of resolution plans, weighs competing proposal and select the one that ensure the value maximization and sustainability of the business. Because COC is also when they are taking the commercial vision decision, that means that they are taking the strategic decisions. Because strategic decisions are those decisions which directly impacts on the business. Ki whether they will, if they will take the decision, maybe business will may survive or business will may not survive. So these are the strategic decisions. These are the strategic decisions which are only taken by the COC. Okay, means main decisions only can be taken by the COC. Not means resolution professional cannot take any strategic decision. Only strategic decision power is given to the COC. Oversight and supervision. The COC supervise the action of the resolution professional and may replace the IRP with another professional if it is dissatisfied with performance, ensuring transparency and accountability. So that is also very important, because resolution professional is working as a facilitator. Resolution professional also have the power and authority as per this code, but they have the limited authority and power. They have to work as a facilitator. They resolution professional cannot take any means decision, commercial wisdom decision. They are also responsible for educating authority. Also means reporting to COC. All the approval is given by the COC. So means COC also supervise and oversight. Okay, now balancing stakeholders' interest. Although composed financial or financial guidance, the COC must consider the legitimate interest of operational guiders, employees, and other stakeholders when approving any resolution plan, consistent with Section 32B of this code. Means if COC is not taking decision in the interest of the all the stakeholders. For example, when we are talking about the operational guider, okay, in operational guider, government authority is also there. If they are not approving their dues, government dues not approving as per this code, so then government authority will also approach to the educating authority. Means operational guiders also can approach to the educating authority. Ultimately, all the power lies with the educating authority. Without approval from the educating authority, resolution plan cannot be approved. If any decision taken by the COC is not aligned with the in legal terms or as per this code, to any agreed party, whether employee, whether operational guider, okay, so they can directly approach to the educating authority. That is the means only situation or only option available, because if committee of creditors are not working in the interest of the stakeholders, so then agreed party will have to go to the adjudicating authority. They don't have any other option. But As per this code, COC will have to work in the interest of the all the stakeholders, and they will have to balance the stakeholder interest. They are not allowed only to take decision for few lenders or only for financial guarantors. Means if they will take only decision in the interest of the financial guarantor, then what will happen? Then business will impact. Then when business will impact, then business will not be able in position to survive. Then survival mode will not be there in the CRP process. Then company will have to go into liquidation. So the purpose will defeat of this code. So these are the main core objective: time bound, value maximization, and balancing stakeholder interest. These are main three core objectives of this code. If any one of these means objective will defeat, then it means the objective of this code will defeat. If any agreed party is there, they can approach to the adjudicating, and definitely when they will approach to the adjudicating authority will come into the picture, and they will take ask COC to miss in some of the cases. What happened when any resolution plan was there, the COC didn't take the correct decision. Aggrieved party approach to the adjudicating authority. Adjudicating authority means then ask COC to reconsider the resolution plan or to take and otherwise what will happen? Resolution means adjudicating authority will not approve the resolution plan. So then what will happen? Company will have to go to the liquidation. So then all the stakeholders will have to suffer. So means anyhow balancing stakeholder interest must be there, and that's why the topic is this ki transparency and accountability. That's why if there is a accountability, committee of creditors understand the accountability, and there is a transparency, so then what will happen? If transparency is there, so then other जो stakeholders will also know कि what is actually happening. So then they will not feel aggrieved, and they will understand what is the logic for behind this decision. Ensuring transparency and fairness through voting, disclosure, and evaluation procedures, the COC ensures that the resolution process remains fair, competitive, and transparent. Okay, that's why if resolution process is not transparent, so then definitely there may be chance of confusion, conflict, and then there may be other stakeholders may be aggrieved. They feel aggrieved for these type of decisions. So that's why it's mandatory to ensure transparency and fairness in the COC process, so that trust can be developed among the all the stakeholders. It approves information memorandum, sets eligibility criteria for resolution applicants, monitors adherence to the court's objective. Okay, now what are the powers of the committee of the creditors given as per the IBC code? The power of the COC are extensive and decisive. While the resolution professional conduct the CRP, the COC exercise strategic control over all major decisions. Its powers include but are not limited to the following: appointment and replacement of resolution plan. If COC members want to change or appoint any resolution, I means when they are appointing resolution professional or continuing IRP as a resolution professional, so then if 66% majority is there, so then they can appoint resolution professional or they can replace IRP to RP if 66% majority of the voting share is there in the COC. So these are the power of the committee of creditors. They can appoint or replace the resolution professional. These are the powers given as per the IBC code. Approval of resolution plan, that is the main thing for the resolution process. This is the most critical, because everything, I will say कि if everything या most of the thing depends only on the resolution plan. If resolution plan is best or good, so then company will survive. Okay, if resolution plan is not good, so then if not approved by the COC, so then company will have to go into liquidation. So this is the main power given to the COC. They have only the power authority to approve the resolution plan. The most critical power of the COC is to approve the resolution plan under section 34. So that's why when they are approving the resolution plan, so there must be fairness and transparency and accountability, because they are also accountable. They are accountable to all the stakeholders. And transparency, if transparency is there, so then also a resolution applicant will not means if there is no transparency, then a resolution applicant whose resolution plan is not approved by the COC, they can approach to the adjudicating authority. If transparency is there, so then COC also means means uh, means put their logic and their all these systems on their documents to educating authority. What on the what basis these things happen, they can also means put their view. The most critical power of the COC is to approve a resolution plan under section 34. The plan must receive at least 6% of the voting share of financial creditors. The COC evaluates plans based on feasibility, viability, and value maximization rather than on the highest recovery alone. Okay. So this is the most important thing for COC members, because all the resolution plan, when any company go in the resolution process, that means company is not in the surviving mode, and surviving mode can come when any resolution applicant, any other company, any other resolution applicant submit the resolution plan who is interested in the business of that company. If COC members also means go through that resolution plan is good for the company and in the interest of the all the stakeholders, and as per this objective of this code is also fulfilling. Okay, so then they have the right to approve the resolution plan. Unless until resolution plan will be approved by the COC, adjudicating authority cannot approve the resolution plan. Adjudicating authority only see whether legality is fulfilled and resolution plan is as per this IBC code objective. They will not go into the means commercial things. Okay, they will not go into the merit of the commercial things. Now another decision on liquidation. The COC may resolve to liquidate the corporate debtor at any stage before approval of resolution plan. If it believes that resolution is not feasible, such a decision once communicated to NCLT mandates liquidation. Means that is also have the another power with the COC. COC can take decision if they also find or think COC ki revival is not possible, so then they can approach to the NCLT before resolution plan. If resolution is not feasible, so then they can take the decision and then they will approach to the NCLT with the help of through resolution professional. So then they can take the decision for liquidation if survival is not possible for that particular company. Okay, before submitting of resolution plan, they can also mistake the decision and approach to the adjudicating authority for liquidation. So this is also the power lying with the COC. Another is power to extend CIP period, because as we know, as a resolution professional, we have to complete this CIP process within 180 days. If due to any reason, if
Rajinder ji, namaste. I want to ask one question on this matter.
yes, sir.
So, the case is like that. Company CRP started in 2024 May somewhere. Only one COC member who was the FC who initiated the Section 7 matter. In 2025 November month, there is a settlement between the COC member who is the FC and the CD. They come to the one agreement that okay, so and so amount is to be paid and he should be supposed to withdraw under Section 12A. Now the said person is insisting to the CD that whatever is there need to take the prior approval of the RP, but RP is not cooperating.
Mhm.
So what to do in such situation? Whether to wait for the because RP has not done anything except the publishing of the newspaper ad.
See,
And
in that case, now, in that case, you may directly approach to the educating authority. If,
Hmm,
for example, if resolution professional is not working and
hmm,
as per this code, okay, because RP is working as a facilitator, okay, if RP is not listening to the COC, okay, so then COC can directly approach to the educating authority. Then educating authority will take take the action. Whether they will ask RP to take to work as a as a normal process. Other they can also change the revenue professional.
no, here COC member is just bother about their money. They got the money as a CD. I am paying the money also, and I want to get their company back. But both the party is telling that each other, okay, COC is telling go to the RP first. RP is not listening. So in such situation, whether as a CD after paying the payment as agreed to the FC or that is a COC, can a CD directly approach to the AA and request them that okay, the formalities has been completed and RP is not putting the withdrawal. So as a CD, the CD is putting the plan
See,
for the withdrawal to end.
that's what I'm telling you now. Any agreed party can approach to the education authority. In this situation, COC and CD both are aggrieved.
Correct.
So then,
Agreed. Huh.
so that's why na, they can approach to the education authority. If they will go both, so then it will be good because both parties are aggrieved. So when they will approach to the educating authority will take the action.
And as a CD, is it the responsibility of the CD only to release the RP fees or the person who initiated the matter?
See, in first instance, COC should approach to the educated authority. But I'm also again telling you, any aggrieved stakeholder
Hmm.
can approach to the educated authority, na?
Yes, yes, that approaching is okay. Now, my second question is if RP is not putting the withdrawal application for his fees, for entire fees, say if CD is ready to pay say some X amount, but if
Hmm.
RP is insisting that no, minimum as per the regulation, minimum 1 lakh per month is required to be paid. So can the any stand be taken against that? Okay, say take the reasonable fees and close the matter. But if he is not agree, then
See,
can the CD directly approach and court to take the direction?
see, yes, if any dispute is there, you don't have any option to approach to the educating authority.
Okay, okay.
See,
That
means after COC, who is the main custodian? Only educating authority. If any dispute is there, you can approach to the educating authority.
Hmm. I appreciate it. Yes. Thank you. Thank you.
Okay. Approval of interim finance and expenses. Okay, see, COC also have the power to raise interim finance because COC is also responsible to survive the business. If business needs the money, so then they can also raise the interim finance. Okay, under section 28, the COC prior approval is mandatory for raising interim finance, creating security interests, amending capital structure, or undertaking any major business decisions during CIRP. So that is also the under the power of the COC for the survival of the business. They can raise interim finance for the purpose of to survive the business. Okay, they can also amend capital structure because if COC finds key means company have a capital structure and have to pay means heavy interest rate, so they can change the capital structure in such a way key interest cost on minimum side or reasonable side. So these type of decisions can also are also taken by the COC. Replacement or appointment of professional. The COC can appoint registered valuer, legal advisor, or transaction auditor and can replace them if unsatisfied with their work of objectivity. Okay, so that is also very important. means if COC can also replace or appoint professionals, because all approval is given by the COC, so they can take decision related to these things. Approve sale of assets during CRP. The COC has also the authority to approve the sale of unencumbered assets or perishable goods during the process to preserve value or maintain operations. That is also a very important from the power of the Committee of Characters point of view. Supervise of RP's conduct. The COC continuously monitors the RP's performance. See, that point is related to you, which you asked. The COC continuously monitors the RP's performance, ensuring compliance with statutory obligation, fairness, and impartiality. It can seek reports, clarification, and periodic updates on progress. If RP is not misconducting as per this code, so COC can take means replace that resolution professional. Number one. Number two, they can also insist to work as per this code. Means in case if RP is not listening, so they can approach to the adjudicating authority. First, they also have they have the right to replace the relevant professional. The simple process will be this: if they are not conducting as per this code, so they COC should replace the revision professional, because revision professional is to work as a facilitator. Voting and decision making process. Each member of the COC has voting rights in proportion to its financial debt owned by the corporate debtor. Decisions are generally taken by electronic voting after decisions in the meeting. Key threshold.
Sir, can I ask a question?
Yes, yes.
Can you go back to the previous slide? Now, it is mentioned that under Section 28, the COC prior approval is mandatory for raising interim finance. Now, consider a case that interim finance is raised by the professional. The permission of the COC is not there, and eventually what happened is company goes into the liquidation. The liquidator is appointed. The estate is sold. What happened to the interim finance, which was arranged by the resolution professional without the permission of the COC? What is the responsibility of the liquidator with respect to the return of those interim finances which have been raised without COC's approval? Thank you.
Okay. But without COC approval, so means interim finance cannot be taken by the resolution professional. These decisions cannot be taken by the resolution professional. If this thing happened, so COC must have taken means action on that time.
No, it's not about COC must have taken action on that point of time. The
Hmm.
thing is, this resolution professional is responsible to ensure that the value of the corporate data is correct. And toward this, for whatever reason, because there are so many things going on in IBC, especially in the COs, in the CIRPs, um, what if the finance is taken, and there are cases like this also which are happening. What if the finance is arranged? I am appointed as a liquidator. What am I
Hmm.
supposed to do? How should I deal with the situation? Should I approach double A? Should I refuse to, give that money?
See, see
What
in
sort
in
of
that
priority should I give to this?
see in that case, na ki you will have to approach to the adjudicating authority. And on the merit basis, the adjudicating authority will take the decision, because as per this code, this is the dispute, and you will have to approach to the adjudicating authority.
Sir, I think before a RP need or liquidator need to approach to the COC immediate basis. If there was an urgency for the interim finance, he should update and get the ratified that what was the urgency. But in case COC is not agreeing, then he should go to the A.
That is okay, but in retrospective, COC will maybe COC will not means agree on that part. So in that case, ultimately, we don't have any option to approach to the adjudicating authority.
But in such situation, we should not take the interim finance at all as a RP.
RP cannot take
RP has
means
issued.
if RP is raising interim finance, they will have to take the approval from COC. Na, if not taking approval from COC, see, legal action will be taken against the resolution professional. That is the number one, as per adjudicating authority. On the merit basis, what they will take the decision, that depends on the adjudicating authority. But COC, COC's approval, without approval, a resolution professional cannot take the interim finance. If taken, if company goes into liquidation, so then liquidator will have, because liquidator will have to take the decision. So if COC will not approve, and retrospective, in normally COC will not approve because company goes in the liquidation. And when company go in the liquidation, at the time of liquidation, approval was also given by the adjudicating authority. So then adjudicating authority will come into the picture. If a sufficient funds is there, so then there is no problem. Question will come, if sufficient fund is there or not there, then adjudicating authority will have to take the decision on the merit basis. We will discuss, I think, these things now we will discuss in the landmark cases.
Okay, sir.
Okay. Key threshold includes 51% majority. Routine matters such as continuation of the business. With normal routine matters, decisions are taken with the majority of 51%. And critical decisions such as resolution plan, extension of CRP, replacement of RP or liquidation, that is taken with majority of 66%. Commercial wisdoms of the COC. This thing we have already discussed. The concept of commercial wisdom of the COC is one of the most significant judicial recognized doctrine under the IBC. The Supreme Court has repeatedly held that COC, being composed of financial institutions, is best suited to assess the commercial feasibility of resolution plan. Courts and tribunals have a limited scope of judicially review and cannot interfere with the COC's commercial wisdom decision unless they are arbitrary, discriminatory, or contrary to the provision of law. Means if any resolution plan is approved by the COC, adjudicating authority will approve unless and until it is arbitrary, discriminatory, or contrary to the provision of the law. Key judicial pronouncement is there. K. Sridhar versus Indian Overseas Bank, the Supreme Court held that NCLT and NCLAT have no authority to question the COC's commercial wisdom in approving or rejecting a resolution plan. Means NCLT and NCLAT will have.
हो गया सर आपका काम से Zoom Zoom को
Someone is unmute. Please mute yourself.
हाँ कॉर्नर में चल रहा है ठीक है
Someone is mute. K. Sridhar
तो ये
versus.
ऐसे कट वट करने से नहीं हटेगा नहीं मैं गलती से दम मच गया नहीं
Someone is unmute. Please mute.
Mr. Rajinder, can I ask you one question, please?
Yes, sir.
Sir, actually, the question is during this AIRP, ARC has taken over the loan of the bank, right? Now, the RP has filed updated list of the creditors before the NCLT. Now, my question is whether, because the NCLT is asking this deed should be registered. Assignment deed should be registered, then only I will admit the claim. And I am going to take the updated list of creditors. So can you explain, is it possible, because whether this assignment deed is mandatory to be registered or it is no need to get into registration done? So something like that. Kindly please throw the light on this.
Can you again tell me?
Sir, I'm explaining it again. During CIRP, ARC has taken over the loan, right?
Okay.
During the CIRP things.
Okay.
The ARC has taken over loan of the bank. Now, because shareholding has gone to the ARC now.
Hmm.
Now RP has filed the list of creditor, updated list of creditor before the NCLT.
Hmm.
It is a duty of the RP to file the updated list of creditors once there is a new shareholding comes.
Hmm.
Now, my question is whether the assignment deed between the bank and the ARC is mandatory to be registered or need not to register.
See, if as per law, if assignment deed is to be registered, so then it will be registered.
Sir, as per the law, registration is must, but actually the problem is coming because you see, bank has now left the assignment because bank has actually gone now. ARC has came into picture.
But they will have to pay the duty. Now, for example, me if I am not get it registered, so then I will have to go for registration. No? I will have to pay the duty. Now we cannot without paying duty. For example, if I am to pay the duty, if I didn't pay the duty, and if I am submitting the document, so then court will not means accept that document. Anyhow, they will have to pay the duty.
Sir, that's right. But because we have as an RP, we have a very limited time, right?
That's
Because
why that's why
yes.
when you will approach to the educating authority will give you the time before resolution plan. Okay, so you can do the changes after. See, if someone is submitted resolution plan and a resolution plan is approved by COC or educating authority, then you are submitting any claim. So that will be directly means rejected. Okay, before submitting resolution plan, you can do the changes. And if approval is given by the educating, you can approach to the educating authority. As per educating authority decision, you will have to work.
Okay, sir. No issue, sir. Thank you. Thank you very much. We understood.
Okay. See,
You can continue, sir. Thank you.
okay, thank you. Someone is unmute. Can you mute? Who is? I'm unable to understand. Okay. See, we will also discuss the landmark cases. After these landmark cases, na, so many things is clear. Although if anything will not clear, na, so we will discuss after landmark cases.
Sure,
Okay.
sir. Sure. Sure.
Committee of Creditors of Hisar Limited versus Tish Gurutta, the court reaffirmed that the COC commercial decisions are final and not subject to judicial review, provided they meet the requirement of Section 32. Another case was Maharashtra Seamless Limited versus Padmanabhan Venkatesh. The court observed that the value maximization doesn't mean accepting the highest bid, but adopting a plan that is most viable for the data survival, a decision left to COC discretion. So
So
that is
can I request you, Mr. Bankim Shukla, kindly request you to switch off mic. Bankim Shukla, can you just can you just put on mute? Thank you.
okay.
Now you can continue, sir, please.
Okay. See, there was another landmark cases on this topic, Maharashtra Seamless Limited versus Padmanabhan Venkatesh 2020. The court observed that the value maximization doesn't mean accepting the highest bid, but adopting a plan that is most viable for the data survival. A decision left to COC discretion. In this case, what happened? If resolution plan is submitted by resolution applicant, to CSC member, it depends on the means discretion power on the COC, which plan is to approve. But when they are reviewing this plan, their aim must be in the value maximization for the long term run. Not means, for example, if any resolution plan submitted by any party on higher side, that is a one time gain. But maybe that plan is not good for surviving the business. So means decision is to be taken by the COC for in the perspective of long term. But that depends on the COC. That is means depends on the COC. If COC's decision will be the final, but the COC should take decision for company for value maximization in the long term perspective. So these are the landmark cases which give us guidance in case if we are stuck up, in case we face any challenge. So some of times if we refer the case, so the landmark cases give us guidance how to come out of this type of problem or situation. Okay. There is another case, JP Kingston Boulevard Apartments Welfare Association versus NBCC India Limited. The court emphasized that the COC must balance the interest of all the stakeholders, including home buyers, while exercising commercial wisdom. Okay, so these are the landmark cases which we discuss in short. In detail, we will discuss after this landmark case in detail. Responsibility and accountability. While the COC enjoys wide power, it also carries fiduciary responsibility toward all stakeholders. It must act with integrity, transparency, and accountability to ensure that its decisions align with the objective of this code. COC members are expected to evaluate resolution plan objectively, avoid conflict of interest, maintain confidentiality of sensitive information, support the resolution professional in preserving the corporate debtors as a going concern, ensure fairness toward operational creditors and other affected parties. Means ensure fairness toward operational creditors and other affected parties. In other affected parties means who are the another stakeholders than operational creditors. The IBBI in various circulars and judicial pronouncements has emphasized that the COC cannot act arbitrarily or discriminationally. It must exercise its power in a bona fide manner for collective benefit. Okay. Next is need for accountability and transparency under the IBC code. So we can take 5 minutes rest if you want.
Yes, yes, you can.
You can take 5 to 10 minutes rest.
Yes, 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 sure.
Okay, now we can start. Can we start?
Yes, sir. You can start, sir.
Okay. Now, another is need for accountability and transparency under IBC code 2016. Whatever problem or whatever action, whatever decisions are taken by the COC, they are accountable. And they are accountable if there is a transparency is there. So then all the related stakeholders will be satisfied with the decision taken by the COC. Okay, so it means in if transparency is there, if all the stakeholders are satisfied, so then CIP process can be completed within time-bound manner with the value maximization. So we can achieve easily the objective, backbone and base for the CRP process, because transparency must be for every part and process, whether any action, any activity is doing or taken by COC or resolution professional or any other related person. Transparency must be in the system. Transparency is good and healthy from business point of view, for decision point of view, and also to avoid any conflict, any issues between or among the stakeholders. Now, how can means how can means what is the need of accountability and how can transparency should maintain as per the IBC code 2016 to get rid of this type of situation or problem. The committee of character is the cornerstone of the catering control framework under the IBC, because all the commercial decisions are taken by only the COC members and they are accountable for to complete this resolution process along with resolution professional, because CRC also have the power and authority, and both COC and resolution professional have to follow and work as per the IBC code. Okay, the role of the resolution professional and committee of characters is different. Resolution professional works as a facilitator and committee of characters work as a strategic decision authority and have the authority or power to take the business related decision, while the code grants the OC extensive power to steer the CRP. These power come with the corresponding duty of accountability and transparency, because when this code is giving the power, if power is there, so then you have some duties. Okay, some duties and you have some accountabilities. When you are fulfilling your accountabilities, so if transparency is there, so then the smoothness will be there. The COC decisions directly impact not only financial character but also operational character, employees, shareholders, home buyers, and the economy at large. Therefore, maintaining accountability and transparency is essential to ensure that decisions are fair, objective, and consistent with the objective of the IBC. That is very important. Maintaining accountability and transparency is essential to ensure that decisions are fair, objective, and consistent with the objective of this IBC: time bound resolution, value maximization, and balance of stakeholders' interest. Okay, means transparency is essential to ensure the decisions are fair, whatever decisions are taken by the COC. Evaluation of the COC role and imperative for accountability. The IBC marked a fundamental shift from debtor in position model to creditor in control regime. It requires that decisions be rational, informed, and compliant with the objective of this code, and not influenced by extraneous consideration. Transparency requires that the decision-making process with the COC be open, consistent, and traceable. If any decisions are taken by the COC. For example, if these decisions are documented, in case if later on if any stakeholder come and say and raise any query in question, so then with the help of these documents can understand ki what was the rationalize behind that this decision was taken, what was the process, okay, what was the situation. So all those things clarify the transparency, ensuring that all the stakeholders have confidence in the fairness of outcome. If there is a proper documentation, if there is a proper process, so then adjudicating authority will also understand and will take decision in the favor of the COC, because they will also understand if COC took decision related to this issue, what was the logic behind on it, and if there is a transparency, so all the related stakeholders will also understand. The involves proper disclosure, documentation, recording of minutes, and clarity of criteria used for evaluating resolution plans. For example, if the involves proper disclosure, okay, also help in the process of transparency. Documentation also clarify, determine when you are approaching the educated authority, you will have to, maybe sometimes if any stakeholders approach to the educated authority, if you have a proper disclosure and documentation, then you can submit with the educating authority. Recording of minutes, who was the part of that decision, so what was the minutes of meeting, okay. So these are the part and parcel of the process of the transparency and clarity of criteria used for evaluating resolution plan. Okay. Together, accountability and transparency ensure that the COC function as a trustee of public economic interest, not merely as a private cartel of lenders. Okay. So this is important from this from point of view on for this topic. Legal foundation and judicial recognition. The Supreme Court and CLAT have repeatedly emphasized that while the COC commercial wisdom is supreme, it cannot be arbitrarily opaque or discriminatory. Key judgments underline the balance between autonomy and responsibility. Swiss Ribbons Private Limited versus Union of India. The Supreme Court highlighted that the IBC objective is value maximization for all the stakeholders, not merely debt recovery. Therefore, COC must exercise power responsibility, aligning with this court's spirit of fairness and revival. There was another landmark case was there, Committee of Creditors of SR Limited versus Tish Kumar Gupta. The court reaffirmed that while the COC commercial decisions are not open to judicial review, they must be based on the relevant consideration and reflect fairness and equality among creditors. Okay. The court observed that the commercial wisdom does not mean absolute discretion devoid of accountability. There was another case, JP Kingston Boulevard Apartments Valuation versus NBC India. The court held that the COC must consider the interest of home buyers, operational creditors, and other stakeholders to ensure equitable treatment and transparent decision making. There was another case, Valal RCK versus Siva Industries and Holding Limited. The Supreme Court stated that although the COC has a wide discretion, it must act bona fide and within the framework of law, emphasizing the need for accountability in exercising commercial wisdom. So, these are the cases which emphasizing equal treatment and within framework of law and reasoned consideration. So these things are emphasized on these cases. Bank of Maharashtra versus Videocon Industries Limited, NCLT Mumbai. The tribunal remarked that COC conduct must demonstrate reasoned consideration and not appear mechanical or arbitrary, particularly in a multi-debtor or group insolvency situations. Because as you know, Videocon case was a group insolvency cases. As you know, ki, as of now, we don't have a means complete means code, because group insolvency related sections are not in this code. So means committee is working on it. We are hoping group insolvency related section will include in this code. Why accountability and transparency are crucial? Protection of stakeholder interest, that is very important. Why accountability and transparency are crucial? Protection of stakeholders' interest. The COC decisions affect diverse groups beyond financial character, because only decisions are not cannot taken to consider only for the financial characters. Ensuring transparency helps protect the interest of operational character, home buyers, employees, and other affected parties. Okay. If any decisions are taken by the COC, if transparency is there, so then another stakeholder can also have the means confidence and trust in the process. Okay, so they will there will be very less chance they raised and not satisfied with the decision if transparency is there. So, and transparency also protects the interest of the patient character and all the other stakeholders. So means protection of stakeholders is the main and crucial from accountability and transparency point of view in CRP process. Prevention of abuse of power. If without accountability, the COC may act. If accountability is not there, so then see they can use means abuse of power. Abuse of power means they can misuse their power. They can take only decision in the favor of the financial character or few lenders. So means if there is accountability in the system, COC will take decision for the interest of all the stakeholders, not only for the sake of the financial character or few lenders. Without accountability, the COC may act in self-interest, for example, preferring short-term recoveries over sustainable resolution or discriminating among creditors classes. So this means with the help of accountability, COC power and authority is restricted, so that COC will not or cannot or should not abuse the power. So that is the accountability need to be affixed during the CRP process as per this code. Promotion of credibility of IBC. A transparent COC process enhance domestic and global investor confidence in India's insolvency framework, reinforcing IBC credibility as a fair and efficient mechanism. Means, for example, if there is a transparency is there, so then if we are talking about the domestic point of view, so resolution applicant will attract, because if transparency is there, so then more resolution applicant will attract who will means show their interest for to submit the resolution plan related to the particular company which is in CRP process. So maybe it creates the credibility. Not domestic as well as the global investor will also attract, and they will have also confidence in the India's insolvency resolution process. So means if credibility is there, credibility can be created with the fair and efficient mechanism. Judicial and regulatory oversight, transparent conduct, reduce litigation and judicial intervention. Because see, if all the stakeholders are satisfied, all the stakeholders will satisfied when there is a transparent system. If transparency is there, if there is a proper process, and if COC and resolution professional is working and using their authority and power, and they are working as per their accountability, and they are fulfilling their accountability, and proper transparency is there, all the stakeholders will have a means satisfaction, and they will have a means trust on in the system if transparency is there. So in this situation, what will happen? Nobody will aggrieved if any means, otherwise what happens if anyone is not satisfied with the decision of the COC or resolution professional, because transparency is not there, So then they will approach to the adjudicating authority. If they will approach to the adjudicating authority, it will means due to this litigation, what will happen? Means it will take much time. So that will defeat the objective of this code. Transparent conduct reduces litigation and judicial intervention. Court defer to the COC commercial wisdom only when its decisions demonstrate reason, deliberation, and compliance with the legal norms. So that is also very important. Alignment with the code objectives. Transparency ensures that decisions are not merely financial but are aligned with the core objective of this code: revival, value maximization, equitable treatment. Another one is mechanism ensuring accountability and transparency. Several provisions under this code for the CRP regulations aimed to build transparency and accountability in the COC functioning. How it can be done? Disclosure and minutes. If RP must circulate the agenda and documents to all the COC members in advance, minutes of meeting, voting results, and resolutions must be accurately recorded and shared. Okay. If these things are adopted, this process is adopted as per this code, so then what will happen? It means there is a transparency and accountability, and that is very important from survival point of view. Now, decision must be supported by reasons and voting percentage. Okay, appointment of independent professionals. The COC may appoint registered valuer, forensic auditor, or transaction auditor to assist in objective decision making. Independence of these professionals ensures transparency in valuation and information flow. Because if there is a need, so COC also appoints forensic auditor or transaction auditors. It also give us the more transparency about this process. So then all the stakeholders will satisfied decisions taken by the COC, because they are very much aware. They know what is happening. Okay, and what is happening, why this happened, was the process, what was the problem, what was the conclusion, what was the action, what was the decision taken by the COC or resolution applicant. So that these things boost to the transparency. Okay, now fair evaluation matrix. Before inviting evaluation plans, the COC must approve an evaluation matrix, a transparent set of parameters to assess plans of viability, feasibility, and value contribution. Okay, this is also the part and parcel of the transparency process. Equal information access. That is also very important. All COC members must have equal access of information. No member or subgroup should possess undue informational advantage that could distort collective decision making. Okay, it means relevant information to the relevant means stakeholders as per law should be accessed to all these stakeholders. Okay, so that is also very important. If all the stakeholders have proper information, so then it means there is a proper system, there is a transparency. This thing also avoid any confusion among the stakeholders. Now, role of the resolution professional. As RP acts as the neutral facilitator between stakeholders and ensure that COC decisions are recorded, reasoned, and compliant with the code. Voting transparency. Voting must be conducted electronically and the result must be verifiable and auditable, maintaining both confidentiality and integrity of process. Okay, means this is also the part of the transparency. Disclosure of conflict of interest. Members of the COC must disclose any potential or actual conflict of interest, particularly when related party creditors are involved, to preserve the integrity of the decisions. Okay, if disclosure of a conflict of interest also means or potential conflict of interest are also informed or disclosed well in advance, that will also give us the confidence and trust in all the related stakeholders. It means there is a proper transparency, and there is a proper process is there. Regulatory oversight by IBBI. The IBC periodically issues circulars and conducts inspection to ensure compliance with procedural and ethical standards. Misconduct or collusion by COC members can invite regulatory or judicial scrutiny. Challenges in ensuring accountability. Despite existing mechanism, practical challenges remain. Dominance of large lenders, especially public sector banks, often marginalize small creditors. OPQ evaluation criteria sometimes lead to allegations of bias in plan selection. Limited participation of operational creditor restrict inclusive decision because operational creditors are not part of are not the part of the COC. So that's why sometimes question means means raised because they are they cannot take the decision they are not the part of the decision whether if decision is taken by the for the suppression writer, so but they are not part of the COC, so they cannot take the decision. So limited participation of rational character restricts inclusive decision making, information asymmetry and inconsistent record keeping, dilute transparency, lack of express penalties for arbitrary conduct by COC members weakens deterrence. At addressing these gaps through capacity building, standardization of procedure, and enhanced regulatory vigilance is vital. Okay. Now, way forward: strengthening accountability and transparency. Statutory codification of the COC duty. Incorporate explicit provisions defining fiduciary duty of COC members to act in good faith and in the collective interest. So means way forward, how can we strengthen the accountability and transparency? Statutory codification, if statutory codification is there, what will be the fiduciary duty of the COC members, COC. So that will also give us the clear-cut accountability and transparency. Code of conduct for COC members. IBBI may notify a formal code prescribing ethical standards, disclosure obligations, and conflict of interest management. Enhanced disclosure framework require publication in anonymized forms of COC decisions, evaluation parameters, and rationales for plan approval to promote confidence and oversight. Greater representation of non-financial stakeholders in case real estate and infrastructure insolvencies, inclusion of home buyers or employee representative may ensure balanced outcome. But here problem is coming. As per this code, only financial character can be the part of the COC. So means operational character cannot be the part of the COC. The reason behind this is that financial character is capable to take the financial decision related to financial matters and related to business matters. Operational characters are not well versed as financial characters. So that is the reason behind this. Capacity building and training, regular workshops, regulatory guidance, and case-based learning can improve the quality and integrity of the COC deliberations. Judicially oversight on process integrity. Courts may continue to ensure that COC's discretion is exercised transparently and within boundaries of law without intruding upon its commercial domain. Conclusion: the Committee of Creditors embodies the spirit of the creditors driven resolution under the IBC. Power must be accompanied by responsibility. For the court to succeed as an instrument of economic reform, the COC must function as a fiduciary institution upholding the principle of accountability, transparency, fairness, and integrity. A transparent and accountable COC ensures fair opportunity for all resolution applicants. Okay, if accountability and transparency and fairness and integrity is there, so then transparent and accountable COC will ensure fair opportunity for all the resolution. Means if resolution plan is submitted by the different resolution applicant, so they will have the fair opportunity for all the resolution plan. It should not happen if advantage is given or to the related resolution applicant. It should not happen. All the resolution must have fair opportunity to submit the resolution plan, and it can be happen only when there is a transparent and accountable process is there. Trust of operational characters and employee. judicial difference to its commercial wisdom, sustainability and credibility of India's insolvency regime. In essence, the strength of the IBC lies not merely in law but in ethical and transparent exercise of power by the COC. So these are the need for accountability and transparency under the IBC code. First, main thing we have discussed concept of accountability and transparency, legal foundations. Then why accountability and transparency are crucial? That is important. Protection of stakeholders, prevention of abuse of power, promotion of credibility by IBC, judicial and regulatory oversight, alignment with the code objective. What type of mechanism ensuring accountability and transparency? That is important. Disclosure and minutes. With the help of disclosure and minutes, we can set the proper process for accountability and transparency. Disclosure and minutes, appointment of independent professionals, fair evaluation matrix, equal information access, role of resolution professional, voting transparency, disclosure of conflict of interest. So these are the things which help us to set up the proper process which defines the accountability of the COC, which also clear the transparency adopted by the COC, so that Miss COC is also responsible to ensure to ensure the proper transparency, to develop the trust and confidence in all the rated stakeholders. That is very important. So that if all the stakeholders are satisfied with the decision of the COC, so they will not, if they are satisfied, so then they will not approach to this adjudicating authority. Otherwise, if they are not satisfied, so they can approach to the adjudicating authority, and it will delay the resolution process, and it will also defeat the objective of this code. So that's why, to fulfill this objective of this code, it's mandatory and it's necessary to clearly adopt the accountability and the transparency under the CRP process. Now we will discuss what are the key challenges and criticism under the IBC code. After this, we will discuss the landmark cases, because we have already discussed what is the power, what is the need, but as a practical life, we have to face the key challenges and criticism. Okay, what are the key challenges? Committee of Character, key challenges and criticism under the IBC. Despite of the IBC success in introducing a character-driven resolution framework, several practical and structural challenges which are faced by the COC have emerged concerning the functioning of the Committee of Characters, while the code vests COC with wide powers of the absence of consistent checks. Okay, because this code vests COC with wide powers. There are wide powers given to the COC because ultimately all the commercial wisdom decisions are taken only by the COC members. The absence of the consistent checks, because as per this code, there is absence of consistent checks, unequal representation, and verifying interpretation of the commercial wisdom have invited criticism from stakeholders, courts, and policymakers. What are the following? Because unequal representation means we are only taking financial characters in the COC. So that is means unequal representation. Okay. Inconsistent checks, because there is a not mandatory requirement of reporting by the COC. Okay. And verifying interpretations of commercial wisdom. Okay, now what are the key challenging criticism that underline the need for greater accountability and transparency in the COC decision making process? Unequal treatment of characters, secured characters for unsecured characters. That is the means unequal treatment, because if secured character is there, then they will have the right to back their money in priority. Unsecured character is there, so then the allocation of the proceeding will be as per the waterfall mechanism. One of the most persistent criticism in the discriminatory treatment of different class of characters, especially secured and unsecured characters, and financial and operational characters. Under the IBC, only financial creditors from the COC and enjoy voting rights in decision making. Operational creditors are excluded from this power structure, even though they often constitute a significant portion of total liability. So that is the practical thing. For example, if in the business, if company go into the liquidation, if financial creditor submit the case under section 7 and they are to recover say 5 crore rupees. Okay, yes, for example 100 crore rupees. Okay, now when company is going in the resolution process, there may be operational creditors whose liability is say 800 crore. Okay, financial creditors are 500 crore and operational creditors are 800 crore. Although only financial creditors will be the part of the COC members. Although if operational creditors portion is more than the financial creditor, but because as per this code, only financial creditor will be the part of the COC. So that is the means unequal treatment of creditors. Okay, this is the practical problem, practical challenges, and criticism under the IBC code. That is the criticism under the IBC code. But the logic is very clear because operational creditor cannot take the commercial business commercial wisdom decision. They are not well versed as financial characters. So that is the logic behind it. Okay, so that is the valid logic and valid reason. But that is the criticism. Why we are not taking operational characters to be the part of the COC members. Okay, so that is the criticism. Okay. Now, key concerns. Resolution plans often allocate disproportionately high recoveries.
Sir, I have one question not related to this topic, but I just wanted to know that 10% of the total claim is one operational creditor or aggregate operational creditors altogether for sending the notice to the operational creditors.
I couldn't get you.
So that 10% of the total claim, operational creditors are having more than 10% of the total claim. Is this aggregate all the operational creditor or one creditor?
One.
Sir, but in one of the disciplinary committee order, I've seen that it is aggregate. As per law also, we can see that it's one operational creditor. But in one of the matter, the disciplinary committee has taken action against the RP, not sending the notice to the all the operational creditors aggregate having more than 10%.
See, actually, we have to follow the follow the IBC code. As per IBC code, if you are doing na, so then there is no problem. Whatever code is saying na, we have to do as per this code.
So you mean to say, sir, then one individual creditor having more than 10%? Okay, thank you, sir.
Resolution plans often allocate disproportionately higher recoveries to secured financial creditors, leaving negligible amounts for unsecured and operational creditors. Such outcomes, while justified by commercial wisdom, sometimes contradict the principle of equitable treatment under Section 32B and Regulation 38 of the CIP regulation. Judicial stance, SRC case. The Supreme Court upheld differential treatment as permissible, but stressed that it must not be arbitrary or discriminatory. Means, in this judgment, it's clearly mentioned treatment is permissible because as per code, financial character and operational character are treated differently, but decision taken by the COC will not be discriminatory. Okay, so that is the clear cut judgment on this part. Illustration in ISAR Limited, Satish Kumar Gupta, the COC approved resolution plan offered around 92% recovery to secured financial creditor and less than 5% to operational creditor. The court upheld the plan but emphasized that the COC must apply its commercial wisdom in a fair and equitable manner, keeping the court's objective in mind. Okay, that is important. Now, there is another is MSME and operational creditors remuneration. Micro, small, and medium enterprises and operational creditors often have little to no say in the resolution process. their interest and secondary to the financial guarantors. Issues operational guarantors are invited to COC meeting but cannot vote on any matter. Okay. Operational guarantor don't have the right to vote, and if they will not vote, so it means they are not participating in the decision making process. MSC frequently act as a supplier and service provider while a large corporate debtor defaults. These small creditors face several liquidity crises but cannot influence the process of resolution. Many MSMEs also lack resources to pursue litigation or challenges unfair resolution judicially and policy developments. The MSCB Amendment Act was section introduced 250 provides a certain relaxations to MSME promoters, allowing them to bid for their companies, recognizing their limited representation elsewhere. However, two participatory inclusion of operational characters in COT decisions remains elusive. Example, in Benani Industries Limited versus Bank of Baroda, the tribunal stressed that all the stakeholders, including operational character, must be treated fairly and equitably. In it condemned COC approach that marginalized operational characters merely because they are lacking vote right. Means operational character must be treated fairly and equitably. Okay. Although decisions are taken by the COC, in the COC only financial characters are the member, but decision taken by COC must be treated as fairly and equitable. Okay. It should not, it cannot happen, and it will not happen, it should not happen as per this code, ki they will not treat it as means fairly or equitable, because all the decisions will, whatever decision will be taken by the COC will be applicable to the financial character as well as operational character. Okay, decision can be taken by financial character, but decision will be applicable both in terms of fair and equitably. In okay, now overpowering role of financial character, that was another criticism. The COC composed solely of financial characters whilst dominant decision making authority. This has led to concerns that decisions may reflect banking recovery preferences rather than broader resolution objective. So that is also the criticism. But in practically, sometimes we see decisions are taken means for means focusing on the financial characters part, but it should not happen. Code doesn't permit this thing. As per code, all the decision will be taken in the interest of the business, not only interest in the few lenders or financial characters. So that is the criticism, overpowering of role of characters, because as we know ki in COC only financial characters are there, not operational character, not government authorities, not any other or stakeholder, not resolution professional. Only voting authority, voting power is with financial character who are the member of the COC. So that's why, as per this code, power is only given to the financial characters who are the member of the COC. So that is the fact we cannot deny. But as per this code, we have to follow. Concern. Decisions may be guided by individually recovery interests instead of maximizing value of all the stakeholders. The voice of minority financial guiders like NBFC, mutual funds, or bondholders often gets subdued by the majority vote or large banks. In certain cases, the COC approaches has led to liquidation over viable resolution, contrary to the court's revival objective. That is also fact. Judiciary reflection. The Supreme Court in Swiss Ribbons and JP Kingston emphasized that the COC decision should reflect collective commercial wisdom, not self-serving motivates. So they also defining to be all the decision must be collective commercial decision, not self-serving motives. Okay, because when COC will take decision only in their interest, so that means that is not the objective of this court. Because objective of this code is to decision taken by the COC must be in the interest of the business so that business can be survived. Because in the CRP process, our main objective is to survive the business. Okay, and survival of business is there when any decisions are taken only in the interest of the business. When any group, any stakeholder will take decision not only no in the self interest, so then it will impact on the business, and when it will impact on the business, so then survival will not be, yeah, may not be possible for that particular company, so that will defeat the objective of this code. Now, delay due to litigation over COC decisions. While the IBC mandates time-bound resolution, COC decision often trigger extensive litigation before NCLT, NCLAT, and the Supreme Court. Okay, sometimes what is happening, if COC is not taking decision fairly and there is not a transparent system, so aggrieved stakeholder can approach to the adjudicating authority. If aggrieved party is approaching to the adjudicating authority, so then resolution process is not possible to complete in the time bound manner. So means delay due to litigation over COC decision. If COC decision is not means not transparent, okay, if stakeholders are not satisfied, so then there is this type of problem are being faced practically. So that's why there is a need for accountability and transparency by the COC. So that's why there must be emphasis for the transparent system, so that to ensure that all the stakeholders are satisfied and they are well versed and they are getting all the proper information. So then if they are getting the proper information and there is a proper system and transparent system, so then they can also means have a confidence in this means decision. So if they are satisfied, so then they will not go to the adjudicating authority. Now, reason for delay: challenges by operational guidance or unsuccessful resolution applicants, allying bias or procedural irregularities. Okay, we sometimes operational guidance approaching to adjudicating authority, or sometimes what is happening if unsuccessful resolution plan submitted by different resolution applicant. If COC accept resolution applicant plan approve out of three, so then another resolution applicant may approach to the adjudicating authority on if they are means allying bias or procedural irregularities. Dispute over eligibility under Section 29, a valuation methodology or distribution mechanism. Lack of clear record of COC, rationalized, discussed later, making judicial review inevitable. The 330-day deadline is frequently breached. The prolonged litigation leads to erosion of assets value and loss of investors' confidence. The JP Infratech insolvency lasted over 5 years, largely due to multiple rounds of litigation arising from COC decisions and plan evaluations. Now, issue in valuation and plan evaluation. Valuation forms the basis of COC commercial decision making, yet it is an area plugged with inconsistency and opacity, challenges wide variation between fair value and liquidation value reported by registered valuers. Okay. See, wide variation between fair value and liquidation value. See, when any company is in the CRP process, so then going concern approach is adopted. So then our purpose is to maximize the value of the assets to sustain the business. But when company is in liquidation, so then our objective is to sell the business. So then value of the asset will be generally less during the liquidation process as compared to the CRP process, because in CRP process our objective is to maximize the value within time frame. Okay, but in liquidation we have to close the business, we have to sell the assets. After selling the assets, we have to distribute the sale of the proceeding to all the stakeholders as per the waterfall mechanism. COC members sometimes rely excessively on liquidation value, disregarding long-term viability or strategic potential or resolution plans. evaluation metrics approved by COC are often vague, allowing subjective interpretations that favor certain bidders. What are the consequences due to this? Dispute among bidders and allegations of bias in selection, judicial intervention questioning COC transparency. There is a related case in Omkara Asset Reconstruction Company versus Resolution Professional of Unimark Remedies Limited. The tribunal observed that COC must document objective reasons for plan selection, especially where the differential is marginal. Okay, means if proper documentation is there, proper process is there, so then any aggrieved party is approaching the adjudicating authority, so then COC also must submit their documents through resolution professional. What was the base of that decision? Limited participation by operational guiders through financial affected remain passive observers in the process. They can attend meetings only if invited. No voting right regardless of claim amount. Information asymmetry operational guiders often lack access to the data, room, or complete plan detail. So that is the limited participation operational guider. We have already discussed this thing. What is the judicial outlook? The pioneer urban land and infrastructure versus Union of India judgment recognized the unique position of home buyers as financial guarantor, ensuring limited representation. However, its similar inclusion for other professional guarantors remain pending. Now, another criticism was their ethical dilemma for bankers, bank representative on the COC, ethical and institutional conflicts in balancing fiduciary obligation to their bank with collective duties under the MSC. Whether to approve a plan with partial recovery now or hold out for higher value. Managing conflict between public accountability and commercial pragmatism. The fear of post-facto investigation discourages bold decision-making, resulting in risk-averse behavior. The government and RBI have issued several circulars protecting bankers and prosecution for bona fide commercial decision in IBC cases, acknowledging these challenges. Then another criticism was the lack of uniform criteria in decision-making. The code provides no standardized methodology for evaluating or ranking resolution plan because as per this code, we rely only commercial wisdom decision can be taken by the COC. So that's why it depends on the wisdom of the commercial COC. So in practically also, if we will set up this standardized methodology, that means we are respecting the decision commercial wisdom decision taken by the COC. So there is a lack of uniform criteria in decision making. The code provides no standardized methodology for evaluating or ranking resolution plan. Different COC use different evaluation metrics, leading to inconsistent outcomes across similar insolvency. See, in practically, the company's business nature may be different, situation may be different. Okay, so there may be chances of different criteria. On that basis, COC is taking decision. So, in practically, should there must is there need for a uniform criteria in decision making? Practically, answer is no, because it depends on situation. COC take decision on the basis of means company's situation or position. Every company's situation position is different. That's why this is the from the criticism point of view. There is not a uniform criteria in decision making. Concerns absence of prescribed evaluation benchmark results in subjective scoring system. Resolution applicant often allege bias and lack of transparency in the selection of process. So that is the also criticism. Some COC prioritize upfront payment, other long-term sustainability without uniformity or rationalize. Because it depends on the situation, but COC should take decision from the long-term perspective in the interest of the business, not for one-time transaction. Suggestion IBA may consider developing model evaluation framework to guide COC, ensuring. See, IBBI also develop model evaluation framework to guide COC. They can set the framework to guide, but they cannot restrict. Na. COC will be able to follow the rule and regulations as per the IBC code. But if there is any guidance, so they can also refer the guidance. For just an example, if a registered value is submitting their report, valuation report with the COC, COC can take decision related to the valuation plan, referring the registered value report, but it's not mandatory they will take the decision only on the basis of the registered value report. Okay, they will use their means authority, power, and experience, skill to take decision related to the evaluation plan. So the IBA may consider developing model evaluation framework to guide COC, ensuring comparability and fairness while retaining flexibility. Another one is criticism is inadequate record of COC rationalized. COC minutes often lack detailed reasoning. That is also the criticism, because these things are affecting and stopping to the for the purpose of transparent process and system. COC minutes often lack detailed reasoning. Means COC minutes must be detailed reasoning for key decisions such as plan approval, rejection, or liquidation. If proper detailed reasoning is there, so what will happen in case of any dispute? Okay, so then if resolution professional is approaching the adjudicating authority and submitting these documents in case of any dispute, or if any query or any question raised by the resolution applicant or any uh, stakeholder. So if there is a detailed reasoning is there, so it will automatically justified. Okay, if this thing is also there, so they will also develop the trust and confidence in the stakeholders and the resolution applicant. So means in the absence of this thing, so there is a problem. Inadequate record of COC rationalized. Issues, decisions appear mechanical and lack explanatory justification. So these are the issues. When challenged before tribunals, absence of detailed records weakness the COC defense and invites judicial scrutiny. So that is the problem. Okay, if there is no absence of detailed records, if proper detailed records are there, so that will be good defense for the COC, and it will not take much time to take decision by the adjudicating authority, because adjudicating authority takes time in the absence of the detailed records. So this is the main issue and problem. When challenged before tribunals, absence of detailed records weakness the COC defense, because it weakness the defense of the COC and invites judicial scrutiny. It also reduces transparency for other stakeholders, including operational guiders and regulators. So these are the issues due to the inadequate record of the COC rationale. If records are proper, detailed record are there, so that means stakeholders will be more satisfied. So then they will not means there are very much there are very less chance to challenge related to the decision. So in that case, if although if means if there is a challenge, so then COC can put their point and put their defense means with proper strength. So in that case, decision can be taken by the adjudicating authority in time. Now, example in IDBI Bank versus JP Infratech Limited, Anclate 2019, the tribunal directed this that COC minutes must clearly record deliberations, reasons, and dissenting views to ensure procedural fairness. Okay, so this case also emphasized COC meetings. There must be clearly record deliberations, reasons, and dissenting views to ensure procedural fairness. Means procedural fairness can be when you have a detailed documentation, reasons, and proper minutes of meeting are there. So then that will be good defense for the COC. Now, judicial review versus commercial wisdom. The tension between judicial review and COC commercial wisdom. remains a recurring theme in IBC jurisprudence. Courts generally defer to COC commercial decisions, SR limited. However, the defense is not absolute. Court can intervene in case of the procedural irregularity, malafide, or disregard for COC provisions. See, we also already discussed about court also approve the resolution plan, but court will check the procedural regularity, and if that resolution plan is fulfilling the statutory provisions and fulfilling the objective of this court, so they will approve. They will not go into the merits and in detail in the resolution plan, because that is not their job. Okay, because the expert defined as per this code is the COC members. They are expert in their field. For example, register valuer expert in their field, registration professional is expert, and other professionals are expert in their field. Court will not come into their work area. Court will only see there is procedural regularity is there, compliance is there, statutory provisions are fulfilled as per this code, so they will approve the resolution plan. There is initial judicial perspective. K. Sridharan versus Indian Overseas Bank. Anclate and courts cannot substitute their view for that of COC. Another case, Phoenix RC Private Limited versus Paid Financial Services. Commercial wisdoms must be based on relevant and lawful consideration. Okay. In another case, while RCK and Siva Industries, COC decisions must be bona fide, transparent, and reasoned to merit judicial defense. Conclusion: the judiciary has consistently reminded that commercial wisdom is not a commercial absolutism. Accountability, transparency, and adherence to this code objective are implicity limits of the COC authorities. So that is the conclusion. Now we will discuss the landmark cases. See, there are very important landmark cases related or on this topic. So these landmark cases are very important because when we are taking any decision, if any dispute is there, if any means clarity is not there, so then these cases really guide us how to come, how to deal this type of situation. So that are very important. Landmark case on the role of the Committee of Creditors, need for accountability and transparency under the IBC code. First case we will discuss, K. Sridharan. We will discuss what was the issue, what was the conclusion, what was the judgment given. So means in light of this landmark cases, we will be able to know how to deal this type of situation. Now, K. Sridharan versus Indian Overseas Bank. This is one of the earliest and most significant judgments on the supremacy of the Committee of Creditors under the IBC. The Supreme Court held that the commercial wisdom of the COC is paramount. Okay. This is already defined, and this we already discussed. Commercial wisdom of the COC is paramount. Means if any decision related to the commercial wisdom decision by the COC is the final, unless and until it is against the law and cannot be questioned by the adjudicating authority or appellate authority. And the court clarified that as long as the COC decision adheres to the provisions of the section 32 because of the IBC and the prescribed procedure is followed, judicial interference is not warranted. Okay, so that is very important. Means all these decisions are final. No question will be asked by the adjudicating authority or appellate authority unless and until it is not as per the provisions of this code or as per if they are not fulfilling the statutory laws provisions. Okay. However, the upholding the COC primacy, the court also understands code that the COC must act in good faith and within the framework of law to achieve court's primary objective of value maximization and timely resolution. This case laid the foundation for recognizing COC as the key decision-making body, but implicitly required that its action be guided by accountability and fairness. Now, Okay, now there was another case, Committee of Creditors of Visal Limited, Sishwar Gupta. In this landmark judgment, the Supreme Court elaborated on the extent and limits of the COC commercial discretion. The court reaffirmed that the COC decision on the feasibility and viability on a resolution plan falls within its exclusive commercial domain, and the NCLT or NCLAT cannot interfere with that decision. However, the court added an important qualification that COC must exercise its power in a transparent. See here, commercial decision is final, taken by the COC, but court is adding important qualification. The COC must exercise its power as per this code, no problem, but in a transparent. This case is also emphasized in a transparent, fair, and reasoned manner. Okay, means if transparency is there, there must be a transparency, fair, and reasoned manner. So this case is also emphasized on this point. COC must exercise its power. Okay, CSC can take any decision as per this code, but all the decisions must be transparent, fair, and reasoned manner. The COC should record its rationale for approving or rejecting plan. The COC should record its rationale for approving or rejecting plan, ensuring that the process is neither arbitrary nor discriminatory. Okay, the judgment emphasizes that while equality cannot be enforced among different class of creditors, because in this code, financial criteria are only the part of the COC. So that's why they are emphasizing equality cannot be enforced among different class of creditors. The COC decision must have a rationale based on be consistent with the court's objective. The decision that thus strengthen the concept of COC, accountability, and transparency, requiring decisions to be fair, informed, and duly recorded. Okay, so this case is also very important from this point of view. In this case also they are emphasizing COC can take decision that will be final, that will, but it must be and should be a transparent, fair, and reasoned manner. Okay, so this decision thus strengthen the concept of the COC, but strengthen accountability and transparency, requiring decisions to be fair, informed, and duly recorded. That is also very important case, landmark case. There is another third case we will discuss. Maharashtra Seamless Limited versus Padmanabhan Venkatesh and others. The court in this case reiterated the principle that the commercial wisdom of the COC cannot be second guessed by the adjudicating authority. Okay, even if the resolution plan offered a value lower than the liquidation value, the NCLT could not reject it, as the COC is the best position to determine what maximizes value in a given situation. The court again emphasized that the COC decision must be made transparently and after proper evaluation of all relevant information. The judgment reinforced judicial restraint while reminding COC members of their duty to make informed and fair. It is also emphasizing whatever decisions are taken by the COC related to the resolution plan. If resolution plan is less than the liquidation value, NCLT will not come into the picture and ask question. Okay, unless if it means COC can take decision whether in the interest of the business. Okay, whether value is less or more, they are not means concerned means as per adjudicating authority. They will see only ki whether this resolution plan is transparent means or fulfilling all the statutory provision of this code. So they will look only this thing. They will not go into the merit and demerit of the resolution plan. Whether, for example, if somebody submitted resolution plan, say 800 crore, another is submitted 790 crore. If resolution plan means approved by the COC 790 crore, the court will not ask, because they rely on the COC members. They have means evaluated the resolution plan in well. The decisions are taken commercial decision by COC. They are well versed in this in the area. So means they are not. It means ki they are not second guessed by the adjudicating authority. If everything is okay from legal point of view, so they will approve the resolution plan. They will not ask any question from the COC. Now there is another case, JP Kingston Boulevard Apartment Welfare Association versus NBCC India. This case involved home buyers as a financial creditor and dealt with their participation rights in the COC. The Supreme Court held that the COC must act in transparent and fair manner, providing adequate information to all the class of creditors, including home buyers, to ensure that the process inspires confidence and trust. The court emphasized that COC decisions should reflect a balanced consideration of the interest of all stakeholders, and that opacity in its proceedings could undermine the objective of this court. The decision reinforced the COC fiduciary character, require members to act with the integrity and in the collective interest. Okay, so that is also a very important landmark case. Another case is also very important, Vijay Kumar Jain versus Standard Chartered Bank. In this case, the issue concerned the right of suspended director to access documents circulated to the COC. The Supreme Court held that the suspended directors are entitled to receive copies of all documents, including resolution plans, placed before the COC. The ruling promoted transparency in the insolvency process and ensured that the suspended management could assist the resolution professional and COC meaningfully. It also recognized that accountability cannot exist without transparency and access to the information. Means, if there is a suspended director, okay, if COC came into the picture, resolution professional came into the picture, okay, if any decisions are taken by the COC, okay, so if there is a need to circulate the COC minutes of meeting, okay, also detail and documents can be shared with the suspended director, okay. So that is also the part of the transparency, because transparency means कि every related stakeholder knows what is happening and what on what basis that was happened and on what basis that decision was taken. So means, if transparency is there, so in this case also emphasize and focus on the transparency कि we need to share detail and document to the all the stakeholders, all the means relevant or related stakeholders. I will not say कि they need to circulate outsiders. Means this information, who are the stakeholders, relevant stakeholders as per this law, we need to share this detail and documents and this information. In this case also emphasize that the decision taken by the COC related all the detailed documentation plan also need to share with the suspended directors. That is the part of the transparency. In this case also emphasize on the transparency in the resolution process to ensure to share the detail also with the suspended management, because suspended management can also help to the COC and the resolution professional, because they were running the business. If they know anything, if COC is missing anything or resolution professional is missing, so they can help. Now there was another landmark case. There is also very important case, Swiss Ribbon Private Limited versus Union of India. Okay, in upholding the constitutional validity of the IBC, the Supreme Court discussed the role and purpose of the COC. The court observed that the financial creditors are in the best position to assess the viability of the corporate debtor, but they must exercise their power in good faith and for the purpose of resolution, not recovery. Okay, in this case now, question raised the constitutional validity. Is the COC means for COC question raised? So the court observed the COC members are only financial creditor, but they are to take decision only in the interest of all the stakeholders with the good faith and purpose of resolution, not recovery. The court stressed that the COC function carries a fiduciary responsibility toward all stakeholders, including operational creditors and employees. The COC is expected to act transparently, responsibly, while keeping in mind the court's objective, value maximization, revival of the corporate debtor wherever possible. Okay, see, means COC have the fiduciary responsibility towards all the stakeholders. Means whatever COC will take decision, will take decision in the interest of all the stakeholders. And the constitutional validity means raised means there were so many questions asked why operational character are not member, why COC have only the financial character. So means in this judgment emphasize that as per this code, financial characters are the member of the COC and they will take decision related to all the commercial decisions can be taken by the COC in the interest of all the stakeholders. But COC is also expected to work as a transparently and responsibly, always keeping in mind the course objective, value maximization, and revival of the corporate data wherever possible. So this was the very famous landmark case on this topic. Another is Phoenix RC Private Limited versus PAD Financial Services. The Supreme Court in this case dealt with the issue of related party financial characters being part of the COC. If there is any related party who is the part of the COC, it held that person who are related party or have collusive transaction with the corporate data should be excluded from the COC to maintain its impartiality, because no related party can be the part of the COC. The judgment protected the integrity and transparency of the COC composition, ensuring that only genuine and unbiased financial character participate in the decision-making process. It reinforced that the accountability begins with the constitution of a fair and independent COC. Because if any related party will be the part of the COC member, so then there may be chance of unfairness, because the decision can be taken in the favor of the corporate debtor, because the code says all the decisions will be taken as per this code to maximize the value, to resolve this resolution process in term bound period in the interest of all the stakeholders with integrity and transparency. So then this case emphasizes that no related party will be the part of the COC members to ensure the fair decisions are taken by DOC members in the interest of all the stakeholders. So that is very important landmark judgment case, because unless and until genuine financial characters are and genuine members means who are not related party are will be the member of the COC meeting, they will be able to take means proper decision, because they will if they will take decision, they will be able to take the fair decision. So that is the main thing, कि related party will not be the part of the COC. So that in this case emphasize that related party cannot be the part of the COC. So that was the landmark case. So these are the landmark cases. There are so many cases related on this topic. I will share this PPT. If you have any query and question, you can ask. Otherwise, we can conclude this session. Can we conclude this session if you don't have any question?
Yes, sir, we can conclude.
Okay.
Thank you very much, sir, for such a nice and interactive and informative session. Sir, you are requested to please share the PPT of the session.
Sure, sure, sure.
Participants, now there is lunch break. Second session will resume at 2 p.m.
2 p.m. or 2:30, ma'am?
2 p.m.
2 p.m. Okay. So again, this will be a 3 more hours, right?
Thank you.
Yes, yes.
Right. Thank you, ma'am.
Thank you, sir.
Thank you.
Thank you,
Okay,
sir.
thank you.
Thank you. Thank you so much. Thank you.
Thank you, sir. Should we remain logged in or should we log out, ma'am? Thank you,
You
sir.
could remain logged in also, no issues.
Okay, okay, thanks, ma'am.
Partha sir, are you here?
Yes, I'm here. We can start.
Shall we start, sir?
Yeah. We can
Good
start.
afternoon. Good afternoon, everyone. Now the session will be taken by Partha Kamal Sen, sir, on the topic commercial wisdom of COC. Let me briefly introduce Partha, sir. Sir is IP, CS, and fellow member at ICAI. He has done certificate course on commercial mediation from Chartered Institute of Arbitration UK and Simon's Advanced Management Development Program from University of Australia. Sir is having more than 35 years of experience in industry in area of corporate secretarial, legal, accounts, finance, audit, risk and claim management, credit control, etc. Sir has also worked with Simon's Phoenix subsidiary of Continental AG, Pricewaterhouse, etc. Now I request sir to start with the session on the topic commercial wisdom of COCs.
Thank you so much. I am audible? Hello? I am
Yes,
audible?
sir.
Okay.
Yes, sir, you are audible.
Yes, you are.
Okay. So good afternoon to all. I welcome you all in this webinar session conducted by ICSI IIP. I thanks ICSI IIP for their invitation to me to speak out here. I also thank all of you for your participation. I found, I think, 83 participants. So, during a weekend afternoon, I think it is a good number of participants. So, friends, today our topic is commercial wisdom of Committee of Creditors. You are aware that in the recent past, GOI, Government of India, has introduced several statutes for the benefit of the business community for ease of doing business. If I am to name, I can name the introduction of GST, then various amendments in Companies Act, in Competition Act, in Arbitration Act. All these things are done with the aim to provide comfort to the business class for conducting their business activities. Also, if you see the recent introduction of Bharatiya Nyaya Sanhita, Bharatiya Shakha Adhidhyam, and Bharatiya Nagarik Surakha Sanhita, known as BNS, BSA, BNSS, by replacing the erstwhile in penal criminal code, then Indian Penal Code, then Evidence Act. All these were introduced by the government, GOI, to provide comfort to the business, to conduct the business within the country. And as a result of which, if you say, I think you are all aware that the index for conducting ease of doing business for India has jumped significantly, which the data published by the World Bank. Another very important and business-friendly statute which is introduced by the Government of India is this Insolvency and Bankruptcy Code 2016. The main purpose of the legislature to bring this code to have a single law, or you can say consolidated law, to address any sort of insolvency resolution process in the country. The legislature has given some uniqueness to this code by providing creditors-driven insolvency resolution process, unlike earlier where it was debtors-driven insolvency resolution process. Here, a single professional named as insolvency professional who conduct the entire insolvency resolution process, and the code has given the authority to the Committee of Creditors to advise and guide that insolvency professional. And here comes the significance or importance, whatever you like to say, the commercial wisdom of the Committee of Creditors. So Committee of Creditors are supposed to provide such guidance or advice based on the, what should I say, I mean, their best judgment, through their best judgment. We will discuss it subsequently. Now, friends, the term commercial wisdom has not been defined in the code. In fact, you will not get the definition of this term commercial wisdom in any act as such. It is a descriptive phrase generally used for business and legal context, which signifies the ability to take sound and practical business decision based on experience, knowledge, foresight, and to judge the market dynamic. This is very important. So, Committee of Creditors are also expected to discharge, to guide, to advise the insolvency professional for conducting the insolvency resolution process of a stressed entity through this quality. Okay. So with this background, let me start my presentation. Let me share my PPT. Just a minute. Is it visible? Hello?
Yes,
My PPT?
yes, sir,
Yeah.
it is visible.
Yeah, it is visible. Thank you. Yeah. So, friends, I mean, I'm sure that all of us have the experience on the effect of commercial wisdom expressed by the Committee of Creditors. So my request to you all that kindly make it an interactive session by sharing your experience or raising your points or make comments on the subject. Please do not indulge it as a monologue type of session. So kindly, I mean, interact and make it an interactive one. So at the beginning, some disclaimer from my side that the views expressed here are purely my personal view. And in case of any legal requirement, I suggest that you please discuss with your legal counsel on the topic. Friends, I said that the recent past, the Government of India has introduced this code, IBC 2016. But does it mean that we don't have any code or law prior to this? No, we had. We had several law, I'll come to that. Several laws which address the insolvency resolution process. But this time, what the Government of India has tried to have a consolidated, to see consolidation of all the existing frameworks by creating a single law. Okay. The Insolvency and Bankruptcy Code was introduced in Lok Sabha in December 2015 and got the consent from the President of India in December 2015, got the consent from President in May 2016 and come into effect from December 2016. So it is going to complete its 10 years. Yeah. It has been made an one-stop solution for resolving, I have already told you, resolving the insolvencies, which is a long process, and I'll come to this. I'll come. So as I told you that there are several laws or acts prior to the introduction of IBC 2016. But these acts or laws, they act in their own, plane. For example, we had earlier Sikh Industrial Company Special Provision Act, SICA, then Presidency Town Insolvency Act, Provincial Insolvency Act, Companies Act also. Earlier, the winding up process, till now it is there, but some changes have been made. So, Surface Act, etc., etc. But all these acts or laws are individual in nature. They are meant for a particular subject, like SICA was only for the Sikh industrial undertakings, who are referred to BIFR. And there is no cohesion. These acts or laws are not complement to each other. So as a result of which the insolvency resolution process became a long run one. And as it is a long run legal process, definitely it is not a cost effective. The cost involvement in resolution process is also very high. The IBC was framed with the intention to expedite and simplify the process of insolvency and bankruptcy proceedings in India. It strives to protect the interest of all. I will see this. Our interest of all stakeholders, make the process doing business an efficient task. It provides strong insolvency framework where the cost and time, since the time has been significantly reduced by the introduction of this code, definitely the related cost, associated cost also comes down significantly. Friends, if you see the objective of IBC, you will see that you will find it in the preamble section of the code, and it says that an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, individuals, all sort of things. Insolvency process related to all categories of entities in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all stakeholders. Friends, these two objectives, actually these are directly related to our today's discussion topic, is the promote entrepreneurship and balance the interest of all the stakeholders. Through the commercial wisdom, the Committee of Creditors should choose the right resolution plan for the trust entity, or you can say the corporate debtors. And while choosing that resolution plan, it should have the commercial wisdom to strike the balancing interest for all the stakeholders, not only the financial creditors or operational creditors, all the stakeholders involved in this process. The commercial wisdom should address this interest of all the stakeholders. Okay, so these two objectives are directly related to our topics for discussion today. And this objective of IBC, provides some unique proposition to the code. First of all, it is a consolidated law, time-bound process. This is the first time the time period also mentioned in the code itself. Section 12 of the code categorically says the period by which the process should be completed. And it is, much reduced time frame which we have seen earlier. Maximization of asset values, promote entrepreneurship, credit availability, balancing interest of all. So all these things, the objective of IBC provides all these unique propositions to this code. Friends, just now I said that there is no definition of commercial wisdom in the code. But if a careful reading of the code will reveal that code has empowered the committee of creditors to take the informed decision towards the insolvency resolution process conducted by the insolvency professional. While providing guidance or advice, they have, as per the provision of the code, they have all the information to take the informed decision in this respect. Okay. So if you see section 21(1) of this code, the interim resolution professional shall, after collation of claims, should form. So from the very beginning, this committee will be formed so that they are aware of the functioning of the ongoing resolution process, insolvency resolution process, with all the financial creditors who have filed their claims except the related party of the corporate debtor. This is also very important because, I told you the commercial wisdom is the sound and practical decision based on expertise and market dynamics. So the code categorically said that even if a person is a financial creditor, but if he relates to the corporate debtor, he will not be a part of the committee of creditors. So the code has provided the opportunity of the committee of creditors to exhibit their commercial wisdom. Okay. On shifting the focus from owner-driven to creditors-driven, I have already told you, COC plays a vital role in the insolvency resolution process under the code. Okay. The first meeting of COC is required to be held within 30 days of ICT. This is also, what should I say, sort of empowerment given by the court to the committee of creditors, COC. That code by statute direct that insolvency professional that the first meeting you have to conduct within 30 days from insolvency commencement date. I think all of you are aware that when the application is filed, it is insolvency initiation date. It is not commencement. Commencement date starts when the application is admitted by the adjudicating authority. So ICD or insolvency commencement date, within that date, within 30 days from that date, when the application admitted, the first meeting of the COC to be held. And what court further said that in the first meeting, the committee of creditors will appoint the resolution professional for conducting the insolvency resolution process for the rest of the period. Okay. The commercial wisdom of COC is a substantial factor which needs to serve the purposes of the code as depicted in its objectives. We have already seen that as per the objective, first of all, to promote the entrepreneurship is mentioned and balance the interest of all the stakeholders. So these two things, it is expected from the COC that they will maintain these two objectives of the code. Through this, COC decides whether the CD should be revived or liquidated. further what I said, that the code has empowered. In support of this, if you, I can say that if you see section 24(1) and the CIP regulation 18, it is mentioned that a resolution professional may convey a meeting of the committee as and when he considers necessary, and shall convey a meeting if a request to that effect is made by members of the committee representing 33% of the voting shares. So in order to have the informations beforehand, any financial creditors or the financial creditors having 33% voting share, they can ask the insolvency professional to convey the meeting. Otherwise, the insolvency professional will but even in that case also it requires the approval that when that meeting will be convened. So the court provides all sort of decision making tools in the hands of the COC. The first meeting of CC, the interim resolution shall hold the first meeting of the committee within 7 days of filing the report certifying the constitution of committee to the adjudicating authority. It is also important. Notice of meeting. A meeting of the committee shall be called by giving not less than 5 days notice, so sufficient time by the provision of the code. Sufficient time has been given to the COC to see the agenda, to form the decision, business decision on the matter which will be transacted in the meeting. Everybody in address the provide the resolution professional, and such notice may be sent by hand delivery or by post, and in any event served for every participant by electronic mail. The committee may reduce, the committee may reduce the period from 5 days to such other period of not less than 24 hours as it deemed fit. The committee may reduce the period to such other period of not less than 48 hours. Because, sometimes what's happened, sometimes some urgency may come, which the committee should be informed for their decision. So the court said that, in that eventuality, the committee can ratify calling the meeting at a shorter notice than 5 days. But in no case, it should be less than 24 hours. So court feels that for taking the good decision, sound business decision, at least 24 hours time frame should be provided to the COC. And anything they reduce, especially when it is for a real estate insolvency process, the court categorically said that they can ratify, but they cannot say that we will take the notice for less than 48 hours. So at least 48 hours notice to be given to COC members for the meeting. Okay. The contents of the meeting, the notice of the meeting shall contain entirely the following. My purpose of sharing all this information with you to appraise you that, look, to provide the commercial wisdom, proper commercial wisdom, the code itself provide the COC members proper provisions, adequate provisions for discharging their function. So code also said, as per regulation 21, CIP regulation 21, that the notice which is to be given to the COC, that should list the matters to be discussed at the meeting, and separately the issues to be voted upon at the meeting. So the committee the COC should be prepared well in advance what sort of voting the insolvency professional is going to conduct. Copies of all documents relevant to the matters to be discussed and issues to be voted upon at the meeting. So all relevant documents, and that with sufficient period of time so that they can discharge their function properly and provide commercial wisdom. The obligation of the resolution professional shall be satisfied when they transmit the email, and he shall not be held responsible for any failure. Okay. The code also said that at least 33% of the voting share, not the member, not in number, 33% voting share should be present. So the more the stake or more the, what should I say, liability the corporate debtors incurs to a lender, he is given prominence to have the proper decision in this process. All meetings of the committee of creditors shall be conducted by resolution professional, and he shall act as the chairperson of the meeting of the committee. This is as per section 24(2) and regulation 24. At the commencement of a meeting, he shall take a roll call when every participant attending through video conferencing or other audio and visual means. After the roll call, the resolution professional shall inform the participants of the names of all the persons who are present for the meeting and confirm if required quorum is complete. That is 33% voting share is present in the meeting or not. Otherwise, it will be deferred. Next day, same time and place. The resolution professional shall ensure that minutes are made in relation to each meeting of the committee, and such minutes shall disclose the particulars of the participants who attended the meeting in person, through video conferencing or other audio and visual means. So all necessary information to be mentioned in the minutes of the meeting of the COC. And this is very important. The resolution professional shall circulate the minutes of the meeting to all participants by electronic mails within 48 hours of the said meeting. So whether the decision taken in the meeting is properly followed or is properly recorded, that should be ensured by circulating the minutes within 48 hours. So friends, what I remarked earlier, that though the particular thing, the particular term, commercial wisdom has not been defined in the code, but the code has all the provisions within itself to give the opportunity to empower the COC for the strong decision making in the insolvency resolution process. All these sections and regulations, they indicate all these things. Voting share and votings otherwise provided separate provision in the code. All decisions of the COC shall be taken by a vote of not less than 51% of voting share of the financial creditors. But there are certain items for which we will discuss. We require the more voting shares for, make that items effective. The resolution professional shall take a vote of the members of the committee present in the meeting or any item listed for voting after discussion on the same. Because I have already mentioned that as per the requirement, that agenda should mention clearly that which are the items to be voted upon. So code say that we should have the meeting. In the meeting, there should be a proper discussion on the agenda item, and then the voting will be conducted. At the conclusion of a vote at the meeting, the resolution professional shall announce the decision taken on items along with the names of the members of committee who voted for or against the decision or abstained from voting. For each creditor shall vote. Each creditor shall vote in accordance with the voting share assigned to him based on the financial debts owed to such creditor. The resolution professional shall determine the voting share to be assigned to each creditor in the manner specified by the board. That is your total claim amount on the your claim amount on the total claim amount of the corporator will ascertain the voting share for you. Actions listed in section 28 shall be considered in the meeting of the committee. Any action other than those listed in section 28 requiring approval of the committee may be considered in the meeting of the committee. Code has categorically mentioned certain items which has to be done with the approval which have to be done with the approval of the COC. Otherwise, if COC feels that a vote should be conducted, it has to be done. That voting should be conducted. Okay. The resolution professional shall circulate the minutes of the meeting by electronic means to all the members of the committee within 48 hours. They have already seen. The resolution professional shall seek a vote of the members who did not vote at the meeting on the matters listed voting by electronic voting system in accordance with regulation 26. So again, I am telling you, because for the sake of commercial wisdom, it is categorically mentioned in the code or regulation of the process that if a member does not vote in the meeting itself, the resolution professional should have the voting of that member through electronic means. You get my point? I mean, so that proper decision can come out through the COC. In such case, the voting shall be kept open for at least 24 hours from the circulation of the minutes. Again, it is the decision of COC, because COC may say that, okay, we require more time to, form our decision on this particular item, and they can ask resolution professional to put more time for closing the voting window. So here I stop for some time and I invite your comments, if any, your points, if any, or if anyone wants to share your experience. Anyone wants to share your experience on the matters which we have discussed so far?
Mr. Sen, this is Shalini here. I'm a resolution professional and also advisor to RPs. Just wanted to ask a query. You mentioned in your various slides and at various points that the commercial wisdom of the COC is supreme. The only thing I want to ask is that there are many often challenges to that commercial wisdom from the RAs who have not won, the bidders who have not won, or the previous suspended management, etc. So is there a way of constraining that, or is there a way to outright say that because the commercial wisdom of the COC is there, these challenges should not be raised? Or is it every case has to go through the whole process and ultimately the wisdom prevails?
Actually, no, I'll come to this point. Commercial wisdom does not mean commercial arbitrariness. There are many, we'll discuss with many jurisprudence where they said, but one thing is very clear. because our apex code also said that there should not be any challenge to the commercial wisdom. But commercial wisdom does not mean that they will overlook any provision in the code. So
Got it.
arbitrariness, commercial arbitrariness is not allowed, and there are jurisprudence on this.
Got it. And I look forward to your further discussion on this
Yeah. Please,
topic.
please,
Yes.
please,
Okay.
please. So anyone else?
Sir, my name is Vishram Panchpur.
Yeah. tell me.
I have come across situations where after circulation of minutes by the IRP or RP, the committee members,
Yeah.
they suggest changes in the minutes, in the text.
They suggest, sorry,
They suggest some changes in the text
Acha.
of the minutes, what has been recorded as proceedings of the COC meeting.
Yeah.
Now, there is no concept of draft minutes getting circulated and then it is approved by, the majority vote. Here, the minutes are prepared by the RP who chairs the meeting and minutes are circulated.
Right.
But financial creditors or the COC members, at times they suggest changes that
Yeah.
you should record this particular fact in this manner, or
Right.
this should have been recorded, you have not recorded this, or somebody else said this where we argued this. So that may not be really relevant, but they insist on such changes. Now, so what is the responsibility of the IRP or RP in such cases?
Look, I mean, generally this is a practice that whenever you finalize the minutes, I do these things. I circulate it to all the members as a draft. Okay. So somebody can definitely ask me that I have not said these things, or I said these things you have not mentioned. Some changes they can definitely ask. But what I do, first of all, I have a discussion with him. So what I meant by writing these things and what they are saying, where is the difference? I like to sort it out. But if I find that, okay, it is, changing my minutes, I change it. And in the next meeting, when the minutes of the previous meeting is to be ratified, I mention it to the committee. Okay. So all the committee members are aware of these changes. If they have something, they'll speak out. Then in that current minutes, I record. You look in the last minutes under point number this COC has raised these things. This is discussed in the meeting. All the members have said that look, these things happen. And if the majority, maybe that thing will come to the voting. Again, I'm saying that not necessarily the items which will come out discussed mentioned under sections 28 to be voted upon. Each and everything the COC wants that it should be voted upon, the voting should be conducted. So if the voting is conducted, if it is passed by the majority of members, you have to change your minutes. I mean, you have to recirculate, or you can say that I have changed, and in the next meeting you produce the changed minutes of the meeting for ratification.
Okay, sir. Thank you.
Okay.
Sir, one question, sir. My name is Sundar Khatri. So may I ask one question?
Yes, please.
Sir, actually, situation is this. The committee of creditors has approved the plan, resolution plan.
Yeah.
After approval of the plan, they also have approved the OTS. Right? Plan is approved during the CIRP. At the same time, because the suspended director has given a good value. Value means basically the entire money they are supposed to pay. The most of the dues, the OTS has been approved. So now my question is, now the financial creditors has moved the application under section 12A.
Financial, yeah.
Naturally, because they have to withdraw the petition now.
Yeah.
With the full majority. Now, adjudicating authority is quite confused whether how to proceed with it. What do you catch, sir? What do you say about it? You
Actually,
see, that program is
uh,
like, COC is the supreme powers. The major decision has to be taken by the COC.
right.
Now the question is which will prevail over which?
Yeah.
That means CIRP is nothing. The entire process which actually adopted by the financial creditors actually is bad. And the process, the OTS has been approved.
Right.
So situation, is quite confusing about the COC should be regulated in this regard, something like that.
Absolutely right. You are absolutely. That's why I said that commercial wisdom doesn't mean that commercial arbitrariness. As per the provision of the code, if the resolution plan is approved and submitted before the adjudicating authority for approval,
Correct.
the adjudicating authority generally see whether this plan, fulfills the condition mentioned in section 31, 2, subsection 2. Okay, there are certain points mentioned that which the resolution plan should address. If it is so, we will discuss also. I have the slides on this. The apex court say the adjudicating authority cannot challenge the commercial wisdom of the COC.
Absolutely. That is there.
They have to approve the plan. So in your case, if the plan is approved and submitted to the adjudicating authority or NCLT, I think NCLT will approve these things. That OTS, which subsequently they have approved,
Correct.
the COC should apply to it. Or you can also file the application. Hey, look, this has happened. So NCLT, I think NCLT will dismiss that thing. NCLT will not allow this OTS to be approved. But if the plan is approved, but it is not filed with adjudicating authority, and in the meantime that OTS is approved, I think you should call a COC meeting and record it there. And then you follow all these procedures, that withdrawal application, everything. Because it is still approval is done by the COC, but it is not submitted before adjudicating authority for the final approval. Resolution plan, sir, one thing is very clear as per the code, or also there are the jurisprudence, the final approval for the resolution plan will come from the adjudicating authority. You get my point? So if it is not submitted, but COC has approved, and within that time frame, some proposal came and they said, okay, we approve this, we are not, in favor of the resolution plan, we approve this OTS, then you have to call another COC meeting. How this OTS was approved? Through a meeting or just they have given you letter that we have approved this OTS? I don't know. So if there is no meeting, then you have to call. In fact, I guess that there is no meeting. But once the approval comes from a meeting, then I think, for OTS, there should not be, or somebody, then again, I'm telling you that code, look, this term, commercial wisdom, is so important that I said that the code has, you provide that provision in the code that any financial creditor having 33% can ask the RP for call a meeting. So the COC who has approved this OTS, if he has that 33% threshold limit, they can ask the RP that you call a meeting. We'll discuss this OTS there and we will approve this.
Sir, the problem is, sir, frankly speaking and honestly speaking, the COC members, they actually, most of the time we have seen harass the IPs. You see, you cannot go twice. You see, once you already approved the plan.
COC has approved the plan, yes.
Correct. At the same time, after 30 days, they approved the OTS.
No, 30 days numbers, but in the meantime, RP has submitted that plan with
RP has submitted the plan before the
OTS is approved.
Yes, his approved plan has been submitted. Now RP has also submitted the 12A.
No. RP submit. Why RP submit? RP should tell them that we have already submitted the plan. So
Yes,
let
yes, Mr.
first
Sen, I have to. Yes, yes,
the
I have to explain it.
NCLT decides.
Now
You inform
NCLT will
NCLT that look,
decide. The
now
man
you
is pending for more than 6 months or 9 months now. Now where to go? The question is not such. And the moment
yeah,
you see the moment the for the financial creditors, for the financial creditors, CIRP is nothing. That means basically entire process vitiated. Once you approve the OTS, why you carry upon the CIRP now?
I agree, sir. But
I mean,
you know,
these are the basic problem, which is
I
typical
agree.
problem, which is, in the many cases are coming up. Anyway, sir,
The-
Mr. Sen, it was good. Thank you. Thank you very
Yeah.
much.
Thank you. These are all practical issues. You have to handle accordingly, okay? But if you see the provisions, if you want to be within the provision of the code categorically said that final approval will come from the adjudicating authority. If the plan is submitted, it cannot do it. So they can file the application before NCLT. Look, we have a more beneficial way. That's why I say not the striking the benefit for all the stakeholders. If that OTS is really beneficial to all the stakeholders, NCLT will approve it or may approve it. But RP or COC, once a plan is submitted, cannot take their own decision. That I want to mention. Okay. So good. So let
Yes,
move
sir.
to this. Yeah. Any point?
Sir, yes, sir. Please. I am
okay.
Sanjay Kumar Agarwal, insolvency professional. Sir, my query is that if in one COC meeting, the COC with more than 66% voting power approved the resolution.
56%.
More than 66% approved
More
the
than,
resolution.
sorry.
But in the next COC meeting, one of the COC members says that our head office is not agree with this, so that resolution should be curtailed.
Okay.
What should the RP should do?
No, but first of all, I mean, once the COC approved the resolution plan in a meeting, then why?
Not a resolution plan. It is a specific resolution which the COC has approved with more than
draft
66.
resolution plan. Draft resolution plan. I mean,
No.
it is a submitted by PRT.
It is an agenda item of the resolution which has been approved by the COC with more than 66% voting power. Yes, and the minutes has been confirmed by the COC members. And the next COC meeting, one of the COC members says that one of the COC member means bank says that our head office is not agree with this, so we are going back for this resolution. What should the RP should do?
Mr. Agula, I'm not clear. Please, give me the.
I am again repeating.
No, I'm just. I mean, let me finish. You have make the agenda for the approval.
For example, in the fourth COC meeting, I have one specific agenda item for the resolution for the COC, right?
Resolution plan for the COC.
No, not COC, not resolution plan, another resolution under section 28. COC has approved that resolution with more than 66% voting power in the fourth COC meeting. And the minutes has been confirmed by the COC members. But in the fifth COC meeting, one of the members says that our head office is not approving it, and you are requested to put this agenda again, and that this resolution should not be passed, and no action should be taken for this resolution.
And he has more than 66% voting.
In the fourth COC meeting, the resolution has been passed by more than 66% voting power. But in the fifth COC meeting, one of the members says that our head office has not approved it.
What is the voting percentage of that member? What is the
12%,
voting percentage?
12%.
12%. Ignore it. Just mention it in the minutes and ignore it. Because that is passed by 66%.
Yes.
Isn't it? So why you are worried about? Why? But record it in the minute. Record it in the minute that subsequently this gentleman or this company has said that their headquarter is not. They are having this thing. But since the requisite, look, all resolution to be passed with requisite
Yes, more than
over
66% voting power.
whatever, 61, 66, 51, we have to consult, see the particular item and what is the provision in the code. Okay. So if it is done, then many resolutions are there where they have voted against. They abstain.
In this
So
case,
if
there was one problem more. The COC member having 36% voting power, they were abstained from the meeting.
no, but 33% quorum is there for the meeting.
Yes.
So, okay, it is a valid meeting. Sir,
Okay.
I'll discuss this particular, I'll discuss you offline, okay? So, because
Okay.
you know, this is a practical problem, but I suggest you please follow the provision of the code.
Right. Thank you.
एकदम पूरा provision में जो बोला है आप follow कीजिए, and everything you record in your minutes.
Okay.
Minutes of the meeting that's why that gentleman asked, if they ask me to change it, suppose he asks, no, you cannot write it. Discuss it in the next meeting. Then they are asking me to drop these things. If required, if required, conduct a voting. If it is passed by the majority of votes, you have to maintain the same minutes.
Okay, sir. Thank you. Thank you.
Okay.
Sir, alternatively, can we circulate revised minutes?
No, I mean, you don't know that how the others will react on it.
Suppose
you can have
only,
these things, but
suppose there is only single COC member, and that member says that certain items have not been properly explained as discussed, so they need inclusion in the meeting minutes. So can we give them revised minutes?
Yeah, then it is different thing. No?
Yeah.
Always keep in your mind the voting share.
Yes.
If it is 100%, the 100% say that it should be changed. So you have to change it.
Okay. Thank you.
Okay. But record it. I always insist, all of you, that you record it in the next meeting. That they have asked for these certain changes, which is incorporated. So definitely they'll ratify the minutes also. And circulated. So COC members are requested to ratify the minutes of the last meeting. This is a very important agenda point, ratifying the last COC meeting. Okay. Achha, now, you know, we always think that the commercial wisdom of the COC only comes at the time of approval of resolution plan. Friends, I must say this is a misnomer. Misnomer in the sense that what I said earlier, that this is the first time government, the legislature's intention to have a creditors-driven resolution process conducted by a professional, insolvency professional, and guided and advised by the committee of creditors. So this particular commercial wisdom should exhibit by them, the committee of creditors, in all the matters related to this insolvency resolution process. Not only in the approval of the resolution plans. I agree that the approval of resolution plan is very critical thing in this resolution process. But even then, this commercial wisdom, the sound business decision should be exhibited by the commercial committee of creditors in all the matters mentioned in the code for the conducting the insolvency resolution process. And for this purpose, certain items have been mentioned under section 28, which says that resolution professional during CRP shall not take any of the following action without prior approval of the committee of creditors, namely raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. And I am sure you will agree that this requires the commercial wisdom of the COC. If COC blindly said that we don't require, we don't agree, then the CIRP process will be hampered. Insolvency resolution process will suffer. So this item, first item, requires the sound business decision based on what I said, knowledge, experience, foresight, market dynamics. Considering all these things, this should be governed, this should be conducted by the COC members. In fact, all items, because mandatorily this should be a voting item. Create any security interest over the assets of the corporate debtor. All these things will be voting items. And for the voting items, the commercial wisdom will come into the picture. Change in the capital structure of the corporate debtor, including by way of issuance of additional securities, creating record or any change of the ownership interest of the corporate debtor, give instruction to financial institutions maintaining accounts of the corporate debtor, undertake any related party transaction. You can do it. If for the, again, that comes at the benefit of all the stakeholders, if it demands, RP can have the related party transaction, but it should be approved by the committee of creditors, and there comes the importance of commercial wisdom. They agree? Dispose of or permit disposal of shares of any shareholders of the corporate debtor or their nominee or third parties, make any change in the management of the corporate transfer rights and financial debts, okay? Make changes in the appointment. Make changes in the appointment or terms of contract of the personnel as specified by the committee of creditors. So you can come out from any contract, any agreement, but provided it is approved by the COC, and that approval should be based on the commercial wisdom, whether it is the benefit for this insolvency resolution process. The resolution shall convey a meeting of the committee of creditors. The above action shall not be approved by the committee of creditors unless approved by a vote for 66%. So all the items listed under generally it is said that it is 51%. Ordinary resolution, okay. But this item mentioned under section 628, it has to be approved by 66% of voting shares. Where any above item is taken by the resolution proceeding without seeking the approval of the committee of creditors in the manner required in this section, such action shall be void. The committee of creditors may report the action of the resolution professional under subsection 4 of to the board for taking necessary actions against him under this code. So not only the power to approve the transaction, if it is not done, court has also given the power to the COC for taking action. 28(4) says they can apply to the board, IBBI, for necessary action against the RP. Over a period of time, the role and powers of the COC have been further expanded. It is very important to enhance the oversight of the COC over ongoing concern cost of CD. The IBBI has notified that RP to seek approval from COC for all costs, including going concern cost related to the CIRP. Regulation 31B inserted by IBBI CRP Amendment Regulations 2024 by notification dated 15 February 2024 with effect from 15 to 2024. Now, as per this notification, RP has to present all his cost incurred. In fact, I present it in tabular form. What is the cost, heads of the various cost items, What is the budget amount? What is the amount I have accrued till date? How much I have paid? What is the balance? And the entire statement is approved by the COC member through a vote. I ensure that I must have proper approval through a voting by the COC member, because it is now mandatory requirement as per the notification issued by IBBI. In light of this, legal experts are of the view that rather than merely supervising the RP, the COC, by approving all costs, including operational cost, is now entrusted with direct control over the affairs of the city. Creditors-driven insolvency resolution process. Court says so. Court and our regulator, they say so that it should be directed or controlled by the committee of creditors. But again, I'm telling you, I'll come to that. Commercialism doesn't mean commercial arbitrariness. We will discuss. The legal expert asserts, since all costs, including operational costs, are mandatorily approved by COC, the COC practically exercises direct control over the affairs of city rather than merely supervisory one. Yeah. So if you have any question, you can ask me. Otherwise, I'll move ahead. So one of the landmark judgment, Ramkrishna Forging Limited versus Ravindra Lunkar, resolution professional, he is a resolution professional of ACIL Limited. The Supreme Court categorically said that position about the position that partnering in India, especially the Apex Court said that as per the position in India relating the interference of A with the commercial of the COC is not justiciable. The commercial adjudicating authority cannot judge the commercial wisdom of COC. It is directed or recorded from the order of our Apex Court. So what was the case? A commercial resolution process, sorry, ACR, sorry, ACIR, I think it's CIR. So a insolvency resolution process was initiated against ACIL Limited by IDBI Bank. The RA submitted the first resolution plan. After several negotiations, an addendum was submitted to the resolution plan with a raise of payment to the FCs. It was further provided that proceeds to a particular land will also go to the FCs. The final plan was submitted by the RA, and later on it was approved by COC with about 88% total vote. So some plan was submitted. Later on, I think somebody asked me, but it is something different from that. It is later on. When first the plan was submitted, but after discussion, they said that, okay, a particular proceeds of a sale of a land will go to the financial creditors, and some addendum is made in the plan, and then the COC approved that plan with 88% total vote. Thereafter, the approved plan was submitted before AA for approval. So this is prior to submission of plan to AA for approval. And the AA ordered to keep away the resolution plan and directed the official liquidator to provide the exact value of the assets. The moot point here is that the adjudicating authority doubted the actual value of the land, which was subsequently said that the sale proceeds will go to FCs. So adjudicating authority doubted something and ordered the official liquidator to provide the exact value of that particular land. So though it is approved by 88% of COC, adjudicating authority not disapproved but kept in abeyance. They said let official liquidator inform the actual value of the land. In the appeal made under section 51 of the code, NCLAT also appealed the order of NCLT. And therefore, it gone to apex court. So the issue, what are the issues before the Supreme Court? The issues are whether the A was right to go into the issue of revaluation while exercising its power. The fact was the new dispute that there was a clear approval of resolution plan by COC. So whether it is right for the adjudicator to for the revaluation, and this is approved by COC. So whether adjudicating authority can do these things, can keep the plan in abeyance. So decision of the Supreme Court is several judgments were considered by the Supreme Court, like A. Sridhar versus Indian Overseas Bank, Committee of Creditors of Essar Steel Limited, versus Satish Kumar Gupta and others, emphasizing on the point that commercial wisdom is non-justiciable. No, what should I add? Adjudication is possible on the commercial wisdom. Further reference was made to the judgment of Kalpraj Dharmashi versus Kotak Investment Advisors Limited, stating that NCLAT has erred in position as it doubted the merits of the plan approved by COC with sufficient percentage of total vote. So net, if it is approved, I mean, even the appellate tribunal cannot change that decision. Another reference was made to the matter of Pratap Technocrats Private Limited versus Monitoring Committee of Reliance Infratel Limited and another, wherein it was observed that the legislature of India has departed from the foreign. This is very, very important because, all the jurisprudence are generally decided on the Indian context. You can argue that, look, in the similar position, we have different provisions in abroad. For argument's sake, you can tell you. But the main thing the judiciary see that what is the current position in this country. So they have noted, Apex Court has noted that the legislature has departed from the foreign insolvency regime as the format does not provide any ground for review of commercial wisdom. Apex Court said that in Indian context, there is no ground to challenge the commercial wisdom. Whereas the latter means that foreign insolvency regime shows the provisions relating to challenging the decision on the grounds of unfair and unequitable treatment. So in absence of any provision prevail in the insolvency code in India, the Apex Court say that it cannot be done. The Apex Court maintained that it is now well settled and approval is well within the COC's domain as to how to deal with entire debt of the corporate debtor. After several negotiations, a final decision is taken and approved. Therefore, Apex Court allowed the appeal, the order under challenge were set aside. The Apex Court did not send the plan back to NCLT as it will lead to impediment on the objectives of the court, that is quick and town-bound resolution, and directed NCLT to pass the relevant orders within 3. You can see here from here that how important the apex court has given to the commercial wisdom of COC. They not even send back the plan for a further adjudication and approval. They just simply give the direction to the NCLT to pass the relevant order within 3 weeks. By going through the order of the apex court, it is clear that here adjudicating authority was in excess of its jurisdiction. What the authorities apparently did not prioritize is the fulfillment of one foundational principles and objectives of the code. This curtails the vision of legislature, thereby the code which cannot be entertained, and hence the apex court was mindfully appropriate in setting aside the orders as well as interpreting the importance of the objective of the code which cannot be bypassed. So you see that you have seen that apex court also mentioned why the apex court has directed the pass the order with 3 days. They said that one of the objectives of the code is to have a time-bound resolution for the trust company. So if it again send it back, but it is not always correct. Many times apex court also send back the plan to NCLT for further adjudication and approval. So any question you have, any point you have, any concern you have, just pause for some time, and if you have any question, please ask. Any experience you want to share? Anything? Okay. Some other pronouncements on commercial wisdom of COC. In the Committee of Creditors of Esha Steel Limited versus Satish Kumar Gupta, it was reiterated by the apex court that the extent of NCLT's jurisdiction is to the point that COC has ceded to abide with the parameters in the provisions of the code, like maximization of asset value, balancing of interest of stakeholders, etc. It opened. I think in some discussion I mentioned these things also. So if they don't follow, the COC don't follow the principle given in the code or the objectives mentioned in the code, only then the NCLT can interfere. Otherwise, no. In ArcelorMittal India Private Limited versus Satish Kumar Gupta and others, and Swiss Ribbons Private Limited and another versus Union of India, the apex court held that COC's role is multifaceted, from the determination of validity of corporate debtor to ensuring that the plan balances the rights of other creditors, such as operational creditors. So both these conditions, because it is a decision of COC which send the corporate debtor to the liquidation. If COC does not approve any resolution plan, there is no way out for the adjudication, but to order for the liquidation of the corporate debtor. And therefore, if the proper wisdom is not exhibited maybe a really, because one of the objective of the code is also to promote entrepreneurship. Entrepreneurship promotion doesn't mean that always you have the new owner through resolution plan. No. You may have some other means of reviving the corporate existing company. So they said that Apex Code said, look, these two things has to be followed. And if these two things followed by the COC, that decision, that particular decision, that particular commercial wisdom of COC cannot be challenged. So I think I got a question that whether, their decision can be challenged. Madam, before challenging their decision, you must test these things. You must put your points within this parameter. Whether they have violated any objective or any provision in the code, or whether they have missed balancing the rights of other creditors. Okay. Arun Kumar Jagatam Ka versus Jindal Steel and Power Limited and another. The Apex Code observed that the lawmakers were careful and hard-working to ensure that the potency of the code remains strong. A clear evidence of same is amendments brought by the legislature. After the introduction, there are lots of amendments made. It emphasized that innovation from adjudicating authority or the appellate authority should be minimal, and it should not disturb the fundamental principles of the code. You cannot skip the planned abeyance, ask the official liquidator to find out the value. No. It is against the intention of the legislature. All these judgments clearly state that as long as there is no ambiguity or abdication of provisions of the code and regulations, the COC cannot be inquired with matters relating to the commercial wisdom during CIR. There is an absolute protection of commercial wisdom from the judicial review of NCLT or NCLAT. So I have noted down certain cases. There are lots of jurisprudence. And if you are really interested, I suggest that you go through this order. You will find, how important this commercial wisdom, the importance placed on the commercial wisdom of COC. Okay, and I've just provided the gist to for my presentation. So any point you have? Now I want to discuss with you the provisions in other countries, especially the UK, USA, and Singapore, as regards the commercial. In fact, in conducting the insolvency resolution process, because in the earlier, the Ramakrishna, the Apex Code categorically said there is a departure from the principle and objectives as compared to the foreign provisions.
Sir,
yeah, tell me.
Pramod here. I want to request you, before going to the other countries, now the emerging area is personal guarantors, individual insolvency. So when we are talking about the COC, playing with the COC with respect to PIRP, so can you throw some light on this also? How it is different? Any area where we need to keep in mind? Because in PG cases, along with the YPCs, many other persons also who gave some loan or any liability from their side also. So they are also coming. So how to handle the COC, especially in a PG care matters?
First of all, sir, in case of PG, there is no COC, there is creditors. Here, COC is the committee of creditors, which are essentially financial creditors.
Correct.
But you are right. They are also creditors. They should play their decision. But you know, the main difference between the CIRP and that PIRP, personal guarantors case, are that first of all, the PG should furnish a repayment plan, and that is totally in his domain. You cannot challenge. You can only approve or disapprove that repayment plan. You cannot challenge it. Look, this is absent. You don't have this asset, or you have shown this asset in excess value. No. You get my point? So there is a difference between the functioning of the creditors. I mean, I'll say creditors because, you know, here it is the financial creditor, there is all creditors. So there is a difference between the functioning, but definitely, yes, you're right. I mean, in the sense that they are also the commercial wisdom. If you approve the, you know, anything for any approval, you have to exhibit the strong business decision, sound business decision. And this comes from that very, very four qualities. From your knowledge, from your experience, from your foresightness, from the market dynamics. So in that case, that also have the same, that there also requires the same quality for the creditors to approve the plan. But here the process is something different. There, first of all, there is a, because what you said, it's a bankruptcy, that is also the functioning is different. Bankruptcy trustees also differ. I mean, okay, there they control the assets of the personal guarantor, but the functioning is different than the, I mean, the process, sorry, not functioning, the process is different than the process of CIRP. Here some outsider put the plan after getting all the information about the corporate debtor. And there the COC has to, because you know, when the plan comes, the commercial wisdom demands that this plan should address the interest of all the creditors. It is, I showed you now that case, the apex court say that ArcelorMittal case, that it should address the all the creditors, not only the financial creditors. Or maybe, I mean, for the sake of simplicity, the court says that all the financial creditors will, because their stake is, generally, it is seen that their stake is high in the process. So all the financial creditors will form the COC, but they have to address the balancing the interest of all the stakeholders. Am I clear? I mean, you get your answer on.
Yes, to extent we got the answer.
Thank you.
But as the time comes, along with the CRP, let's throw some light on the PIRP also, because it's an emerging area that we are going to face practically now.
Okay.
Thank you.
Anyone else? Or shall I? Oh, just a minute. So shall I move? Okay. So UK, if you see in UK, the Insolvency Act of 1986 is in place, where the insolvency is called the administration. Here it is called insolvency resolution process, but there is called insolvency administration process, or administration, not process, this insolvency administration. Objectives of the Act are similar to those in India, like rescuing the company as a going concern, providing results to the creditors, maximization value of assets, and balancing the interest of all the interested parties. A wide range of powers has been given to the administrator, who is under the duty to act in good faith and in impartial and independent in managerial affairs of the company. So, friends, can you mark the difference between Indian context? Otherwise, I can tell you that provisions of the IBC Indian law and the UCO laws are more or less similar. In fact, in Indian insolvency law is more akin to UK insolvency law. But can you mark the difference here? Just I pause for something. Just give a try. What difference you can identify between India and UK? Any guess? I think the answer is given in the subsequent line.
That is right. I think in the UK, the administrator, who is analogous to the RP, seems to be having more commercial decision-making powers and can only be challenged if, he's gone against the interest of the COC through a separate process. Whereas in India, it is the COC which is driving and the RP is only supposed to facilitate, as you had also mentioned earlier.
Yeah, more or less of the target, but even then, the RP can form this is mentioned here. The creditors can form a committee in order to assist in performance. But here what's happened, it is mandate. Mandate has been given to the COC to guide and advise RP. So, I mean, now more and more regulation comes and more, I think the amendments will also come. Bill will be passed in the next parliament session, where RP is more or less under the control of COC in India. It has no power to exhibit on its own. It has to work. That's why the Apex Court says that it is a departure from the insolvency laws in abroad. Intention of the legislature is to empower the COC in conducting the insolvency process. So here, if you see the UK provision, they said creditors can form a committee in order to assist administrator in performing his functions. Whereas India, COC is in the driving seat. RP performs the function and assisting the financial creditors and COC. Okay. The legislature of UK has provided the provisions for challenging the conduct of administrator. Yes, you are right. In case the practices go against the interest of creditors or in cases misfeasance. So in that case, administrator is COC here. Whereas the general impression in India that their decision cannot be challenged. But okay, there are some, I will come to that. There are some deviation. But general impression is that their decision, commercial wisdom, their decision cannot be challenged. But in UK, administrator can be challenged. There are statements of insolvency practices in place for standardizing the conduct of administrator, liquidators, etc. So, okay, we also have the regulations for the conduct of IP, but according to me, in UK, it is more structured in discharging the function by the administrator. It has a standard format or standard, what should I say, principles, guidelines, how the RP or administrator will discharge his functions, both in liquidation and in insolvency resolution process. In UK, Creditors Committee has limited role, that is to assist administrator insolvency professional in carrying out his duties, and can only ask the court for appropriate action in case administrator misuses its power. So, Committee of Creditors, I mean, they have very limited role in it. In USA, Chapter 11, because Chapter 11 is the reorganizations, I mean, something akin to our CIRP. Or Chapter 7, liquidation. Survey are the main options for corporate reorganization. So it is called Chapter 11 either, or for a revival, or Chapter 7 is a liquidation or dissolution of the company. Chapter 11 deals with the reorganization of the corporate entities in the similar manner as that of CIRP under Indian insolvency regime, while the purpose of Chapter 7 is to optimize the recovery of different creditors of the debtors vis-a-vis liquidation. We also do it the same way in the liquidation. We form the liquidation estate, sell the assets, and pay off the creditors. Chapter 11 provides for a provision where the debtor remains in control of the business operations and repays the creditors via a reorganization plan approved by the court. Another difference I think we have marked. In Indian insolvency law code or law, it is now creditors-driven operation, controlled by insolvency professional, supported, guided, or advised by the COC. But in USA, while conducting the Chapter 11 reorganization, debtors remains in control of the business. The corporate debtor or the borrower, they remain in the control, but they form the repayment schedule via reorganization plan, and that should be approved by them. Here. So these are the difference in Indian scenario and USA scenario. The US trustee, an official from US Department of Justice, has the duty of overseeing the development of a Chapter 11 case and managing the operations of debtors in possessions business. So not only that, it is a sort of, what should I say, not court-driven, but your Department of Justice. It is a government department. Huh? Some officials from that government department will oversee. There is no administrator, no insolvency professional. It is conducted by the process conducted by, in USA, by the debtors himself, but he is under the control of an official who belongs to US Department of Justice. The court may appoint an examiner to investigate the case in cases of fraud, mismanagement. So more or less, I mean, it is court control. In USA, it is more or less government or court controlled activity. Incompetence by the debtor. Incompetence by the debtor. The court can also order the takeover of the management of the debtor's business by the trustee. So debtor's control will go. It comes under the trustee. When a trustee is appointed, the debtor forfeit his authority to be in control and is obliged to transfer the management of his business to the trustee. The trustee takes the place of the debtors board of directors and takes on the responsibility of the business's executive leadership and administration in a way that is comparable to the RP during CIRP in India. So only when the court orders for the appointment of trustee, then some similarity comes with the Indian provisions. Otherwise, you get my point. I mean, otherwise it is completely different from what you have in India. Yeah. The USA Bankruptcy Code stipulates in section 1129A7 that a reorganization plan must fulfill specific criteria to be accepted, such as obtaining the vote of at least one impaired class in the event of any impaired classes under the plan. So it demands in USA, as per the provisions of insolvency law in USA, it demands that the consent of at least one impaired class who are affected by the resolution plan, framed by the debtors for reorganization. Under USA law, a committee of unsecured creditors can be established to advocate for the benefits of all general and secured creditors and maximize their returns. The creditors committee typically assumes an active role in representing the interest of the creditors. The creditors committee plays active role in decision making and fast tracking the insolvency process. I think it is mentioned. USA bankruptcy regime is debtor friendly and provides engaged participation of some degree of power to the unsecured creditors. Again, there is a deviation from Indian context. In Indian context, COC formed by the financial creditors were unrelated, but in case of USA insolvency law, there may be a committee, but that committee consists of unsecured creditors. And of course, it is debtors friendly because debtors keeps the control unless and until the court directs for the appointment of a trustee. Clear? Singapore, the insolvency process in Singapore is called judicial management and is supervised by the court. So according to me, the USA process and Singapore process are more on, has some similarity. I cannot say that it is similar, but has some similarity because it is totally supervised by the court in Singapore. Similar to the CIRP, the objective of judicial management processes is to rehabilitate financially distressed companies. The judicial manager, a licensed insolvency practitioner, oversees the judicial management process and has a broad range of responsibilities, including managing the company's affairs, business, and property, taking over the director's functions, and performing all duties in the best interest of the company's creditors. But again, please remember that he is supervised by the court. Though a licensed insolvency practitioner is handling, but he is supervised by the court. Court monitored process. The judicial manager carries out the same responsibility as that of RP, as well as exercises the commercial wisdom of COC, all within the overall supervision and active participation of the court. But I said that it is supervised by the court. A distinction can be observed of the position in India as the function of RP and CRP are connected but well defined, whereas in Singapore, the judicial manager performs the function of RP, including the exercise of judicial wisdom. So in India, RP and CRP are different but well defined. I mean, they're connected but well defined. The role of RP is defined within the IBC. The role of COC is also defined in the IBC. But in Singapore, the judicial managers, they function as the RP, and he exercises judicial wisdom. He is performing as per the court direction. The same person. Okay. So these are all the provisions of the insolvency laws in other countries. I have considered only 3 countries. There are other countries also. So again, my question, you have any point, anything you want to discuss? I just pause for some time and invite your comments, points, any experience you have.
Sir, I have one question about the individual person. If you want to initiate the insolvency like Section 10 in CIRP,
Section 10.
Section 10, corporate debtor can go themselves.
Uh-huh.
So on the same footing, if individual or partnership firm wants to initiate the insolvency, old laws are there, Provincial Insolvency Act, and one more is there, 1909 and 1920. But practically, if we approach to any court and sincerely, if anyone wants to declare the insolvency himself, that I'm not able to get exactly practical solution how to proceed that application, under which court and under which act.
Now, I mean, there is the provision. Chapter 3 deals with the individual and partnership firm. LLP comes under these things. LLP will be governed by Part 2. Any limited liability partnership will come under Part 2, and that's all the provisions related to the CIRP will be applicable to LLP also. But if it is a partnership firm is governed by Part 3 of IBC. But Part 3 is for the individual and for the partnership firms. Okay. So this is not yet notified. Only except that personal guarantor. So, only some provisions of Part 3 related to the personal guarantors who has given guarantee against the loan given to the corporators, they have been included. They have been included in the provision of IBC and notified also. But till that partnership or individual has to go for the earlier, because these two acts, the Presidency Township Act and Provincial Insolvency Act, has not yet been repealed. SICA has been repealed by the government of India. The provision has been, what should I say? They are not in, how
not repealed means they are still in force.
They are still in force. If you have something, you can, but definitely, if you see the annex schedules to the IBC, it is mentioned that it has replaced. IBC has replaced that Presidency Township Insolvency Act and Provisional Insolvency Act, but not yet notified for the individual and partnership. So for that purpose, you have to go. Once the Part 3 is notified, then these two acts will also be repealed by the government.
Correct. So my question was, if as an individual, anyone wants to declare the insolvency, then what is this practical solution available? How to approach which court and under which any process is laid down or not?
Definitely, we have to see those two act. I mean, I'm not aware of these things, but definitely their provisions will be there.
May have any thought.
I'm not aware of this, but definitely someone, since these are still in vogue, so definitely some provisions will be there. That how the individual can declare himself as himself. Okay. But if it is a personal guarantor, if you ask for a personal guarantor can declare himself, I mean, can bring himself under the insolvency by section 94. But in that case, he should be a personal guarantor to a corporate.
So in that PG case also, sir, that date of default, I'm not getting that point. How to decide that date of default particularly?
I couldn't come again. Sorry.
Date of default. How to decide that date of default?
Date of default, when the date of default is now very well defined in the jurisprudence. Default is when the guarantee is invoked by the financial institutions. The date of default will occur from that particular date. The limitation period will start from the date when the personal guarantee, not bank guarantee, personal guarantee given by the PG is invoked by the bank, financial institution, not bank, financial institution. And that particular date will be considered as the date of default.
Okay, and that should be in writing. Bank should intimate to the person.
Of course it should be.
And it may be possible that banker give the loan to the, say, for example, loan given in 2010 and till 2025, nothing has been communicated to the PG, and suddenly they can go for the invoking the personal guarantee. This can be possible.
Yeah, it can be possible because it will not be barred by limitation for the PG. But I mean, for definitely for corporate debtor, I think the limitation will attract. I have to see the case. I cannot comment as such. But for the PG, it will be considered when the personal guarantee is invoked by the financial institution.
Okay, good. And
so
sir,
any question?
Yes, question is one more question. Give some practical experience how to deal with the COC. Sometimes if the COCs are very, if any new RP is there, they don't understand how to deal with the COC. Any practicality you want to share? That will be great help, sir.
Sir, definitely I'll discuss. But I just let me first finish my presentation. Then definitely I will have some time. We'll discuss it. You note it down. We'll discuss it. Okay. At the end of the presentation. Okay. Hello?
Okay, sir. Absolutely okay.
Okay, thank you. Just note it down, and after my presentation, we will discuss. Not only that, I really, I mean, I like the speaking in webinar because it is not that I know many things, you don't know anything. No, maybe I also don't know many things. I attended an webinar and they said that how to become how to publish a book. He said, don't wait for gathering knowledge and then write the book. You said you write the book, then the critics will come to you, tell you this has happened, it is wrong, this is there, here we have made the mistake. And by this process, you will come to know the actual thing. So that's why I like to speak in the webinar. As in the very beginning, I said that you please make it an interactive session. Acha, if we are through, can we have 10 minutes break? Anybody from ICSI here? Because I have, not many slides to cover.
Yes, sir.
So can we have 10 minutes break, madam?
Yes, sure, sir, sure.
So we'll come back at 5 o'clock, 4 o'clock, okay?
Okay.
Thank you. Let it be, huh?
அந்த ஒரு கேஸ்
So can we start now? Hello.
Yes, sir.
Yeah. Thank you.
Yes, sir.
I think the screen is visible. Now I'll discuss with you what you asked me at the beginning of my presentation. Commercial wisdom versus commercial arbitrariness. Whether the decision of the committee of creditors can be challenged in any court of law. Friends, it is my personal view that the commercial wisdom of anybody, not only COC, anybody, should not lead to the commercial arbitrariness, should not lead to any arbitrariness. Because, I mean, in Indian jurisprudence, ultimate thing which is the which prevails is the question of equity. Whether the particular action is justifiable or not. Indian judiciary always harping on that. They're harping on two things. One is natural justice and question of equity. So based on this concept of Indian judiciary, I can say that, again, in my personal thing, that commercial wisdom of COC is not above the law. It cannot be a commercial arbitrariness. But again and again, I am telling you, you have to find out the things. You have to see whether how it is deviated from the provisions of the code, how it is deviated from the objective of the code. And you have to argue before the authority, judiciary authority accordingly. Okay. And there are lots of jurisprudence also where it is said that commercial wisdom is not, absolute. I must use the word absolute. It is not absolute. The role of COC has become utmost importance, agreed, in resolution process empowered with the exercise of commercial wisdom, which plays a pivotal role in deciding the fate of the corporate debtor and balancing the interest of diverse stakeholders. These two things are very, very important. So, because of COC's decision, the fate of the corporate debtor is decided, whether it will be revived or moved to liquidation. And not only that, in a insolvency process, not only the financial creditors, but other creditors are also. So all the stakeholders, whether their interest is taken care of by the decision taken by the FIS. Judicial interpretation of commercial wisdom has not been without scrutiny. Adjudicating as a whole, that decision of COC must align with the legal framework, within the framework of IBC, of the code, and should not be arbitrary or in violation of established laws, question of equity, and thereby maintaining fairness and transparency in the insolvency process. To tell you some judicial pronouncements, Supreme Court of India has taken steps in the direction by limiting the empowerment of COC in M.K. Rajagopalan versus Dr. Perisami Palani grounded case. In the case, the submission of resolution plan was in contravention of Indian law, Indian Trust Act. SC unequivocally held that commercial wisdom of COC should not be overexpanded to brush aside a significant shortcoming in the decision-making of COC, when it had not duly taken note of operation of any provision of law for the timing in force. Even if you see that provision of section 31(2), it categorically said that whether the resolution plan submitted by the RA, whether it contravenes any provision of any law for the timing in force or not. So if it is done in contravention of that, then I think that approval of the plan by COC can be challenged. My personal view that the decision taken by the commercial COC is arbitrary. SC held that the status of COC would not be sufficient reason, would not be a sufficient reason to ignore any shortcomings of the code. Commercial wisdom is accorded a status of primacy in the CIR process, corporate insolvency process, subject to the condition that every aspects of the resolution plan is made available for COC deliberations. So it is the duty of the RP to inform, to deliberate each and every, I mean, in fact, I think you are all aware, whenever you place a resolution plan received from RA in the committee meeting for discussion, each and every aspect of the plan should be discussed and recorded in the minutes. This is mainly because the fate of the corporator is going to be decided through the function or the decision of the COC. Clear? SC observed that if the decision of the COC is in contravention of any law in force, the principle of commercial wisdom cannot be taken as a defense to go forward with the impugned decision, and the same becomes subjected to judicial scrutiny. Madam, you asked me the question. You got the answer now. I think Shalini. No? Hello, Shalini ma'am, I think you asked me the question that whether the decision of COC can be challenged or not.
Yes, that's right.
So you got the answer now?
Yes, it is quite clear. Thank you.
It should not be in contravention of any law in force. And I have given you the case laws. M.K. Rajagopalan versus Dr. Perishami Pilani Gounder, decided by our apex court. Okay. Achha, there are other cases. In Kanwar Sachdeva versus IDBI Bank, Delhi, this is done by Delhi. But so this is not, I mean, directly related to, but it is a civil suit, okay? A Delhi AC observe, but you can, if you have any point, I mean, that's why I'm saying that you first check that why you form this opinion that it is a commercial arbitrage. Then you gather this case laws, and you definitely you can argue before the authority. Delhi High Court observed that with great power comes great responsibility. COC, which is a pivotal body under regime of CIRP, cannot be devoid any code of conduct for its functioning and discharging obligations under the provisions of the code. Delhi High Court said. The COC being entrusted with the fiduciary duty to bring back the corporate debtor, because if you see the provisions of IBC, the prime and first objective of the IBC is to revive the company. First it is revival, if not possible, then liquidation. These two are not parallel activities. This is, what should I say, stage by stage activity. So first, the proper, steps to be taken, proper ways to be find out how to revive the stressed company from its present position. So it is said that Delhi High Court observed that being the interest of fiduciary nature to bring back the corporate debtor from the vicious circle of debt trap and revive the company. It is the duty of COC. must be saddled with the responsibility of ensuring that the decision taken by it in the exercise of commercial wisdom shall be in tune with the bona fide objectives of the court. So whatever the decision committee of creditors take, it should be within the periphery of the code. It cannot violate or it cannot go exceed. Okay, it cannot exceed the provision given in the code. In order to facilitate an effective and responsible functioning of COC, an elaborate, determinative, and efficient code of conduct for functioning the COC assumes the great relevance. It is pertinent to mention that Insolvency Law Committee, in its report dated 20th February 2020, has also recommended a standard code of conduct for functioning the COC. If you go through this Insolvency Law Committee report, you'll find that it is mentioned there. Since they are performing a very crucial role in this insolvency resolution process. So there should be a standard code of conduct, but unfortunately it is not yet done. It is vividly seen that the COC takes the driver's seat in the entire voyage of CIRP of corporate debtor, and the commercial wisdom of COC functions in the same way as global positioning system, GPS, works for the driver in any journey leading the way of the intended destination. Okay. The AA and CLT expressed concerns about the conduct of COC in a number of judicial pronouncements. This is Delhi High Court. I also discussed the Apex Court, but NCLT also, I mean, they expressed their concern in SBJ Exports and Manufacturing Private Limited versus BCC Fuba India Limited. AA observation was that a strange phenomena had developed insofar as functioning of the COC is concerned. In a number of cases, it had been seen that the members of the COC were nominated by the financial creditors like banks without conferring upon them the authority to take decision. So somebody said these things, and so this is observed. So if it is, I mean, I don't know. I mean, I don't encourage these things, but if you want, you can file the application because it is now open secret. Without conferring any upon them the authority to take decision on the spot, which acts as a block in the time-bound process contemplated by the insolvency manual. Because another objectives, one of the objectives is that of the IBC is the time-bound process. These speed breakers and roadblocks obviously cause obstacle in achieve the targets of speedy disposal of CIR process. But friends, again and again, I'm telling you, before jump to any conclusion, you have to have sufficient, or should I say, not proof, but sufficient ground, sufficient logic in favor of your such type of decision. Okay. Accordingly, IBBI issued circular dated 10th August 2018, number IBBI CIRP 0162018, that the financial creditor must be represented in the COC by such person who are competent and authorized to take decision on the spot and without deferring decisions for the want of internal approval from the financial creditors. Here someone narrated the case that they said that our head office is not in favor of this resolution. So that definitely this is all the deviation from this circular. And I don't know, I mean, how, I mean, I have not gone through the case, tell you very frankly. But apparently it appears that this is a deviation of this. When they say that is okay, then they because they don't have the competence to actually, I mean, sit as the COC member. Concerns expressed by legal experts. The legal experts have opined that objective of value maximization during CIR process is defeated if the CD or RP are not provided with timely funding, or if CD or RP are not provided with timely funding, or if they are not permitted to raise interim finance. In numerous instances, RP lacks the necessary funds to undertake compliances and meet legal requirements on behalf of CD. For example, determination of avoidance transaction falls under the domain of RP. However, if COC does not approve the legal cost associated with filing of these avoidance transactions as CIRP cost, RP lands into great difficulties even to perform his assigned responsibilities as per the law. So we already discussed as per section 28 that raising interim finance requires the approval of COC. So my personal suggestion, if in any case COC disapprove the things, I think you can challenge him, but you can say, you can quote all these things, provisions of the code. You can inform them about your difficulties, because here it is categorically say, legal expert says that, look, as per the code, the filing application, forming opinion, determination of profit transaction, filing application is your responsibility. But the fees will come and that fees will be approved by COC. So if it is not done, you should have a discussion with them. Why the amount is not approved? Sure, and the RP will not go and spend the money from his own. A common grievance of RP is that the fees are not approved, paid by the COC for months together, and RPs are often expected to perform their duties without receiving funds and thus compelled to cover costs of their own. According to legal experts, by not allowing timely access of funds to the RP, COC may also bear vicarious responsibility for non-compliances and loss of value of assets. Because all of us know that value, because maximization of value is one of the objectives, and value diminishes over the period of time. Value of the assets diminishes. So they are equally responsible for this. As according to the decision of Apex Court in Swiss Ribbon case, RP acts under the supervision of COC. Some practical issues related to CIR process. Regulation 43A inserted with effect from 14/6/2022 mandates that creditors provide the resolution professional with the latest financial statements and other relevant financial information of the corporate data that they possess. This ensures the resolution professional has a comprehensive understanding of the company's financial situation to facilitate the insolvency resolution. However, when CIR process starts, the accounts of the CD has already been stress assessed vertical of the banks, which may or may not having the entire record. I am telling you, maybe these things are not directly related to the commercial wisdom, but definitely these are the responsibility of COC. Do you agree with me? Because it is as per the regulation mentioned that the RP should be provided, and definitely the creditor, the lenders, the financial institutions, the COC members, when they provide the loan money to the corporate debtor, they have all these documents. But the main problem is that, the NPA is declared by some particular branch, and then it is transferred to the asset recovery or asset management branch of the particular bank or financial institutions. And they say, we don't have any law. So, okay, I agree that this is not related to the commercial wisdom, but this is one of the responsibilities which lack. by the financial creditors or the members of the commercial committee of creditors. Regulation 35A4 inserted with effect from 26/2022. And you can understand that, after, I think, 6 years, 2016, IBC started, and these are all the subsequent amendments or insertion. So definitely, the intention of the legislature to address these things. So even even then, if it is not done, we have to discuss this. The creditor shall provide the resolution from a relevant extract from the audit of the CD conducted by the creditors, such as stock audit, transaction audit, forensic audit, etc. And many, I have seen cases, in many cases, they did it. But if you ask them the document, they will not provide. The creditor shall provide the resolution provision of the latest financial statement of other relevant financial information of CD available with him. Again, due to movement of files from branch to other, many old records are not transmitted, and as such, I have conducted one process where, what's happened everywhere. If you file your application or if you file anything, definitely you have to serve notice to all the party concerned. So the CD is also one of the parties now. So, and I asked for the email address for the CD, because otherwise I have to send the speed post. Speed post will go to and reach him after 3-4 days. Then I have to statutorily I have to wait for 7 days for his reply. He'll provide reply. It will come to me. It is violation of the time-bound process. But the CD say, the bank said that we don't have the email address of that CD. Very strange, I'm telling, but these are the practical difficulties, I must admit. But thing is that because the transfer of files, maybe the file were in some branches, which is, but even then it is not, we will suffer for that. It is the responsibility of that creditor to get the file, all files, related files from his respective branches. So friends, accordingly, IBBI has issued a guidelines for Committee of Creditors functioning dated 6th August 2024, setting that under the Code of Commercial Wisdom, the COC write the procedures to attain the objective of value maximization of the distressed assets. This further states that the number of COC largely represent financial creditors, and most of them are under regulatory oversight of the financial sector regulator RBI rather than the board. As such, this is the main problem. Actually, COC is really under the control of RBI. And whereas we are all, the entire process is conducted by IBBI. As such, to foster more effective and time-bound decision-making by the COC members, these guidelines have been issued to stem the value erosion through curtailment of procedural delays and enhancement of transparency and coordinated approach of decision-making by the members of COC. These are all the, preamble of these guidelines issued by the board IBBI. CC members are now mandated to follow the relevant provisions of the code in both letter and spirit, maintaining objectivity and integrity in their decision-making process. The guidelines would help the resolution under the code in a time-bound manner in the interest of maximization of value of assets of the CD. So what is the guidelines? It is, segregated. If you see the objective and integrity, it mentions that to follow the relevant provisions of the code and regulations in letter and spirit. We have already discussed that anything done, against the provisions or objective of the code and regulations when they are under are altered. follow while performing their roles and functions, the maintain integrity in discharging their roles and functions in as envisioned under the code, maintain objectivity during the decision-making process, foster informed decision-making, and share with COC, insolvency professional, any relevant information relating to transactions, guarantees, recoveries, claims, etc., relating to the corporate data. So they are duty-bound to, share this information to all the members of COC and IP. Because, many times it happens that COC consists of various, it is not a single member, various members of them. So it is a duty of all members of COC to share the information. Independence and impartiality to disclose to the COC insolvency professional the details of any existing or potential conflict of interest arising due to pecuniary, personal, or professional relationship with any stakeholder immediately on becoming aware of it. Professional competence and participation, keep themselves updated with the provisions. That is also another problem. Many times I've seen, what should I say that? They are not very much, I should not use the word conversion, but they are not aware of the provisions, very clearly of IBC. They are not aware of the current jurisprudence passed by various courts on the IBC matters. So the guideline says that they should keep themselves updated with the provisions of the code, rules and regulations, and the role and responsibility assigned thereunder. Nominate representative with the proper authorization, again and again it is mentioning, and sufficient mandate to effectively participate in the meeting. The nominated representative may endeavor to obtain approval of competent authority if required at the earliest, participate actively, constructively, and effectively in deliberation and decision making of the COC. Cooperation, supervision, and timeliness. Supervise and facilitate the insolvency professional in discharging his duties under the code. Facilitate expeditious appointment of various professionals within the timelines prescribed under the code and regulation. This is another problem. This is a practical problem. As per that section 28, you have to have the approval. Like just now we have discussed that the appointment of the auditor for avoidance transactions. So the guidelines say that you have to expedite things. Okay, if you have something, not that you have to give the blanket permit, but you have to have the proper authority to discuss in the meeting and then say whether you agree or not. If not agree, then you state the reason. Then for this reason, we are not agreeing. Ensure at all times complete adherence to the undertaking regarding confidentiality of information. Cost. Make necessary measures to ensure that the insolvency resolution process cost is reasonable. Expeditiously decide on all the expenses to be incurred by the insolvency professional, including the going concern expenses of the corporate debtor and his fees. Prudently fix the fee payable to the liquidator while deciding to liquidate the corporate debtor. Regularly monitor the activities of the insolvency professional and seek rationale of decisions, actions taken by him. Diligently recommend for the inclusion or otherwise of the belated claims collected by the insolvency professional and categorized as acceptable in the list of creditors and its treatment in the resolution plan, if any. Actively participate in the presentation of valuation methodology made by the registered valuers. Ensure the conduct of the meeting at regular intervals as specified in the regulations. Proactively share the latest financial statement, relevant extract from the audits of the corporate debtor conducted by the creditors such as stock audit, transaction audit, forensic audit, etc., and other relevant information available with the insolvency professional to enable efficient conduct of the process. Seek details of all the litigation filed against or by the corporate debtor from insolvency professional and recommend necessary actions to the insolvency professional to safeguard the interest of the corporate debtor. Because, they are empowered to guide also the insolvency professional. Carefully review and assess the information memorandum prepared by the insolvency professional and other additional insights. Duly contribute to the preparation of marketing strategy of the insolvency profession by the insolvency professional and may also take measures for marketing of assets of the corporate debtor if necessary. Ensure that all resolution plans are received by the insolvency professional are placed by the COC. Suitably consider the requirement of a monitoring committee for the implementation of the resolution plan. So all these guidelines are issued or given by the board IBBI to ensure the proper commercial wisdom of COC within the parameter of our insolvency. Okay. So, in summary, I can say the commercial wisdom of COC is a paramount function enabling them to exercise their powers, which goes in line with the preamble and sacrosanct order of the objective therein. The AA has been in excess of its jurisdiction in certain cases. The holds of power by holding that holds the power of COC, but the apex court in most of the cases uphold the vision of legislature, Indian judiciary by providing primacy to the commercial wisdom has unlocked unlimited power of COC. The commercial wisdom of COC cannot be put into question. This is because the committee of creditors are considered as detriment. This is because the committee of creditors are considered as the determinant factors with the duty of maximization of assets as well as ensuring balance between the rights of the stakeholder. If the time and situation demands, more stringent practices can take place again to ensure the mechanism to run efficiently. I must say that, okay, maybe as per the provisions or the jurisprudence is the prime function of COC to display or to exhibit its commercial wisdom, but again and again at the cost of repetition, I should say that it should be within the parameter of the code. Commercial wisdom and commercial arbitrariness are completely two different. But yeah, at the same time, it is a fact that till now, the intents of legislature is to empower COC in conducting the insolvency resolution process of the trust entity. Okay. So I am through with my presentation. Now I open the floor to you if you have any question, if you have any comment, if you want to any chat, anything chat. I think all of you have given your attendance in the chat.
Sir, I have a question.
Yeah, okay.
Sir, in case regular meeting, because of a stay on certain part of the process, if COC is not inclined to do the monthly or quarterly meetings, what should the RP do?
No, come again. I mean, what's happened generally.
Suppose Form G has been stayed, and it's been Form G has been stayed by NCLAT has stayed Form G. And in that case, the COC says that there is nothing much to deliberate upon, so they do not agree for a meeting. Even if you call, they don't come. Then what should the RP do? You ask them a convenient date, then they say, no, we are not inclined for the meeting. Let the NCLAT order come first.
But if there is a stay, how can you conduct the meeting? Stay means the entire process is
stay. No, stay is not on the meeting. Stay is not on the process. Stay is only on publication of Form G. Rest of the process is to continue.
Okay.
So only publication has been stayed, but then there are other duties which the RP has to perform time to time. He has to take care of the assets, take care of the litigation.
Yeah. So, as per the provision of the code, you have to conduct the meeting, you have to give the notice.
Yeah.
If that requisite quorum is not there,
yes,
you have to defer the meeting the next day, same time, same place. Generally, it is through, online, audio visual means.
Yeah.
So even then you record it. You keep on writing the minutes of the thing, circulating.
Okay.
But
so we can just ask them to come, and if they don't come, we cannot do anything unless and until the matter proceeds.
You can do no. You first you write the defer. If defer, you have to defer the meeting first.
Yeah.
Same day, next day, same time, same date.
Suppose the next day is Sunday. So the deferred date is Monday.
Monday. Okay. And then even then there is no quorum, 33%. You record everything and finalize your minutes.
Okay.
Circulate it. But I think you have an agenda item now. You can put the agenda item. Informing the decision of NCLAT. Whether I also got some stay order. I continuously monitoring that decision. Hearing of
the process.
Process of NCLAT, and I inform them. I inform them in the meeting. I put a agenda item that intimating the decision of NCLAT.
Okay.
Because I think generally NCLAT holds all its hearing once in a month.
Yes.
Definitely. So that will be an agenda item, and you ask them.
But generally, most of the months, the cases are not taken up, not reached because of too much cases listed above your case. So there is nothing in the order as such. For almost 1 year, there is nothing. The matter could not be reached. So even the order doesn't have anything. It just it says that could not be taken up due to paucity of time.
So you do one thing. You do your duty. You call meeting.
We have only the duty to call the meetings. If they don't come, then we cannot do anything.
But you finalize the meetings also. Circulate.
Okay. So without the meeting being there, can we finalize the minutes? Whether it can be called minutes.
Meeting is cancelled. Cannot be held due to the
due to non-appearance of any of the COC members.
Quorum.
Yeah, in absence of quorum. Okay.
And you write that the members present all are absent. But you have to keep your paperwork in properly.
Okay.
So that nobody can hold you responsible. Blaming. Why you have not called the meeting? You have to have the solid documents.
Thank you, sir.
Anybody else? Ideally, I want to hear from you your experience on the commercial wisdom. I am sure that you have handled the CRP process.
What he was asking, so at the adjourned AGM also the member present, even if one member present, that will become the quorum.
Sorry.
I only have one member. So doesn't become a quorum.
Then I agree. Only one member, yes, absolutely. Adjourn meeting, there is not necessarily 33%. One member will form the meeting. Absolutely. So, anyone else?
I can see Anil Murarka ji, past president of ICSI, is also there. I think he can say something.
Yeah, sure.
Anil,
I don't think the presentation was so well articulated, and I think
Thank
it
you,
was
sir.
explained in simple terms. That is more
Thank you.
important. And I
Thank
believe
you.
that all the participants must have enjoyed this deliberation. Thanks to all
Thank
of
you,
you,
sir.
and thanks to Mr. Singh.
Thank you, sir. Thank you so much.
sir, you can share your experience also on that. Anything. Anil sir,
Me? Achha,
My
okay.
experience.
you can add on or anything you can say.
I tell you, which I tell to everybody, that whenever this insolvency law was drafted as part of the council, and I thought that it will open a lot of opportunities for company secretary professionals, but it's not like that. Again, in the NCLT, the advocates are only there. If any advocate friend is there, don't take any exception to my statement. But somehow it was a big opportunity for me as a company secretary, but we somehow could not take the benefit of this.
Sir, here I would really want to say something, my feelings, again, my personal feeling is that somehow we professionals other than advocates, we are suffering from some inferiority complex.
You're right, sir.
But believe me, I have seen that we know better than these advocates.
Sir, I fully agree with you.
Only one thing we lack is the court etiquette. But that hardly take any time to learn.
Yeah. You're right,
You
sir.
have to be very polite in putting your points. Don't argue with the opponent. That's all. Otherwise, knowledge-wise, I have seen they are much better position than these advocates.
Yeah, you're absolutely right, sir. I fully endorse your view.
So only because of some inferiority complex.
No, sir, we may be good at facts, but sometimes they are good at law. So both have to go hand in hand.
No.
They are not good at, they may be good at law, but the way they plead, at times that makes a difference, I think.
Yes.
Absolutely.
The
Because
way
they
of
know
pleading makes a difference.
They know the etiquettes, how to plead, how to, what's happened. Once I was told that in a day, you are seeing only 2 judges in front of you. But these judges are seeing thousands of pleaders, are the persons who plead before them. So obviously, they are also human beings. No? They have some, what should I say, that mental, so you have to consider that things. You should
Sir,
not.
I tell you with my experience, before NCLT, even the NCLT judges are appreciating the presentation of the company secretary. I've seen and they have accepted me.
Absolutely. I fully agree.
Sir, here it is the other way around. If you appear with your advocate, they don't allow you to speak. The advocate has to speak.
And that's okay. Why you appear with your advocate? You appear on your own.
Even in NCLET also, they prefer that advocate should speak. The RP should not speak unless and until asked.
Because the person sitting on the other side are also from that background.
Yes.
Absolutely. Absolutely. That's okay. No, but if you don't, here also, many seniors, I have professionals, I think they appear on their own.
Right.
One thing, filing, your progress report, I think that you don't require the help of any advocate. You can go on your own, can say, this is my progress report. Report carries this page to this page. Affidavit carries this page to this page. That's all.
Sir,
So
I tell you, in Simla
why,
High Court,
why you engage here?
sir,
So
in
I
Simla High
wanted
Court,
to.
I appeared. In Simla High Court, I appeared with an eminent personality of India. He is a judge. He is an advocate. But when I started to speak, the judge interrupted me. But the advocate said, no, no, sir, let him explain the facts. He knows the facts better than me. And judge allowed me, and I got a lot of appreciation.
I fully agree. You are absolutely right, sir, because facts are known to you much better than your advocate, because you are the person on the ground.
And I tell you, practicing company secretary, by and large, they put in a lot of efforts in whatever work is being given to them.
Yeah, agree. Fully agree.
So I wanted to add something here. I am registered with ICICI IPA, but I'm not a company secretary. I'm an engineer MBA. And I think that insolvency professional requires many different competencies or many different types of professionals to make it a diverse array of people who are working in it. There are operational aspects, there are other aspects. So I think the point you brought about that, it should not be just maybe only one type of professionals should be overwhelmingly there. All different professionals can contribute to it, and it should be like that.
You are absolutely right.
Absolutely. Only
Sir, thank you. It was a wonderful presentation. We liked it.
Thank you, sir. Thank you so much. Thank you.
Thanks a lot.
So, thank you, sir.
Thank you so much.
Thank you so much, sir, for a very nice presentation.
Thank you.
Thank you very much, sir.
Thank you, sir.
So, anyone?
Thank you very much, sir. Session was very informative and very good session was there. Sir, kindly share the PPT with me.
Sure, I sure. So, can I take your leave? I thank all you. I really like these things, because again and I'm telling you, I like to speak in webinar for the interest of me also. In this process, I come to know many things. So I really like this, because it is a very interactive session. So through interaction only we can exchange our opinion. We come to know each other difficulties. We can discuss to get the solutions out of it, isn't it? So thank you all once again very much for your attendance. I'm sure that.
Yes, sir. Thank you.
Thank you,
Mr. Singh. Thank you.
Thank you.
So I take your leave.
Thank you very much, sir.
Yes, and ma'am, please share the attendance. Please give us the attendance, because we have to file for the CPRs. Yeah, please send the attendance.
So we will share it by Monday.
Okay,
ma'am. Thank you.